5, 4, 3, 2. All right, I made it.
2 seconds early, Vince.
Oh, shoot.
All right, 105. Okay. Where
A lot of people are back.
were we? Okay, welcome back to the meeting. We are on examinations, now item B, action on revisions to the testing accommodations rules. The recommendation to adopt, recommendation to the Board of Trustees to adopt them. And I presume seek the court's approval after the return from public comment. Christina and Robbie and Dr. Kyle. Hello.
Hi, Christina. Can you go ahead and get started on that, Christina?
Yep,
Yeah.
sorry, I had to adjust my volume. Thank
Thank you,
you.
Christina.
So this agenda item is coming back from the second public comment period. And I do want to acknowledge the public comments, noting that this agenda item was posted on Wednesday. The public comment period closed on July 31st, and it did take some time to compile the feedback that you see today. The working group is bringing this agenda back to the committee today for the full discussion. The committee received 42 public comments and a comment chart which summarizes the public comment positions as well as the full public comments themselves are included into the attachment as attachment A and B. I do want to call out some of the themes received from the written comments. Some of them were also verbally discussed today during the public comment period before the CBE meeting. The definition of disability was called out. And the state bar, I'm sorry, is that just?
Christina.
Okay. The definition is taken from the ADA, and the state bar maintains that this definition is appropriate within the rules for testing accommodations. The public comments also pointed out things such as stop the clock breaks, with the state bar typically does not grant. However, we do grant, rather than stop the clock breaks, extra time built in. It's just that the clock will continue to run during that extra time. Other themes talked about the diversity of the consultants that the state bar hires, the training and supervision and the leadership. The state bar is absolutely committed to enhancing the diversity and inclusion and has increased the number and the diversity of expertise in its pool of consultants. Staff leadership in the committee training is equally important. Staff and leadership take part in annual training, and on the CBE's work plan, there is also training scheduled for the committee members itself. Other themes talked in public comments talked about excluding the law school grants as part of the automatic process. And again, the law school grants are not in the automatic approval process. However, it is taken into consideration when reviewing files that the applicants have submitted. Public comments questioned the definition of exceptional request being capped at time and a half in a private room. Some of the committee members have had a discussion about law school grants and capping the exceptional request at time and a half. Two of proposals that the committee or that the working group discussed are in the agenda item. And another one of the themes discussed within the written comments centered around the timelines. both the response by staff timeline, the public comments really want a response within 2-week time frame, and extending the appeal timeline. The public comments are asking for 30 days. And again, the working group had a suggestion about extending the appeal timeline for the applicants that file on the timely filing deadline, which is approximately 60 days before the final filing deadline. And at that point, I think that concludes all the highlights. And again, want to open it up to either Dr. Cow or Robbie. Either of you want to speak a little bit more?
Yeah, this is Robbie, Dr. Cow, if you don't mind if I jump in, because I have spent a lot of time on this with Christina and my own review. I want to make a couple comments and then tell you what I recommend, which I believe is aligned with the staff recommendation, and then I'll be anxious to hear what other members think. You know, about the very late submission of a lot of materials, I do want to say that the materials prepared by the bar itself of those 250 pages were 8 pages. The other 242 pages were the public comment. And fortunately, many public commenters chose to, I think that a certain sort of static standard response, public comment response was passed around, and you will find that on 60 or 70% of the public comments, the exact same public comment. So it was easier to digest because many people and agencies put forth the same thoughtful comments for the bar to consider. Probably the thorniest issue for applicants and for the bar are these timeline issues. I believe the best way to address that is to require that all applicants, not just applicants requesting accommodations, apply sooner than is currently provided by statute. And that would require a statutory change to require, as many other states do when I reviewed this, that applicants submit applications for the next bar with more of a time lag, particularly for anyone that wants anything other than a standard issue seat for the bar exam. Christina, I can't remember, what is the current latest time that you can apply? Is it 30 days before the bar?
It depends on, if we're just talking about the bar exam, it's about 45 days. It's the first of the month preceding the bar exam. So for July bar, it would be June 1st.
So what I'm hoping in a robust discussion, because this is an ongoing discussion on how best to manage applications for the bar, including, of course, accommodated applicants, to advance that date so that there is sufficient time for applicants who are seeking accommodations to present their documentation and for that to be reviewed by the bar. Now, I think the second way to make some headway here is to see what can we do in terms of an automatic grant? What can we do in terms of what applicants submit, in terms of how we can quickly process that and keep moving so that nothing else is required? Well, there are 2 ways, and one of the speakers, one of the public commenters this morning, Claudia Center, she wondered why there's a distinction between automatic approval for things granted in law school and automatic approval of granting double time. She thought that those things should both be considered together, as many public commenters did. But I disagree, and I'll tell you why. We don't know And we do know there is a wide variety of methods employed at the law school level for granting of accommodations. There's no standard. And what our goal here is to level the playing field for all applicants. And I can't say that we're doing that when we accept blindly or without question whatever was provided in the 100 or so law schools that will be presenting applicants to us to sit for the bar. There's no standard that the bar requires, and each law school has its own method of granting accommodations in the classroom, for classwork, for homework, for law school exams. There's no consistency. So I believe that law schools rely and wish the bar to do its own check to make sure that the playing field is being leveled with accommodated applicants. And there are, as our rules say, we give great deference to what law schools have done, but it is not automatic. With respect to the other way to streamline this a bit, the automatic granting of up to and including double time when it has been approved by a high stakes exam, I agree. I think that is a great step in the right direction. It's the staff recommendation, and it's going to be mine that we take that step in terms of an automatic grant. And Christina, I'm not sure if you have the numbers, but I believe that is significantly going to cut down on the review time for the bar in terms of getting back to other applicants who may have applications that require more review. I have to say, CBE members, I've been on this committee for a while. Probably I've had my hand in it the whole 6-7 years I've been on the committee of bar examiners, and I am impressed by the review that is provided. I've seen a lot of changes over my time, including the hiring of that independent expert that reviews applications. And my experience is that the overwhelming majority of requests from applicants after review are granted. Christina, you can correct me if I'm wrong, but when I read public comments that say that our review is stringent, stingy, and skeptical approach to granting accommodations, I would disagree. And I'm no rah-rah for the state bar. I'm a volunteer on the committee of bar examiners, and my role here is to help protect the public and ensure a level playing field for applicants. I'm on the committee of bar examiners, so my goal is to make sure that the bar exam is open and fair and that we have a level playing field for all. So, I disagree that the approach taken by the state bar to accommodated application requests is stingy and skeptical. I don't agree. And I think if we can provide more of a time frame for the thoughtful review of the applications, then we're going to be making great headway in satisfying the concerns that are raised in those public comments and raised by individuals who did not public comment but have those concerns. So my proposal, and of course I'm anxious to hear comment from other members, but my proposal is going to be the staff recommendation that extends the automatic approval of up to double time, which we previously have not done, for those who have previously received that accommodation in high stakes exams. High stakes exams, as a reminder, that's the LSAT, the SAT, the MBE, the ethics exam, other independently administered exams where we know what rigor is taken to ensure that those accommodations are appropriate. So, Christina, I kind of blabbed on there. Was there anything that you wanted to add to clarify my comments?
No, although I do have another thought, but I don't want to jump in front of Dr. Cow if he wants to talk anything about the subject before the rest of the committee members also jump in.
Yeah, if I may just have a word, Christina, I do want to share with the public that like Robbie, I'm a volunteer. In fact, I'm a non-attorney volunteering to ensure that there is public protection. And what I've seen in my time, when Robbie speaks very eloquently and very well articulated, are the thoughts that the overall intention of the bar is to make sure that students who need accommodations receive accommodations. At the same time, not to repeat what Robbie has said, but he's really highlighted the major issues that have come up when the working group has evaluated with time and effort to try to see how do we improve this overall process. So I would second Robbie and Christina's thoughts, and I'm also very interested to hear from our other CBE members what their thoughts as well. Thank you.
If I may just, I wanted to point out one other thing before everyone else starts speaking, is that the rules, as we propose different options, are included in the agenda item. And you're going to see one change that I didn't address in the agenda item, and that is a public comment that was made earlier today about applicants requesting the same TA. And the change that was made in the rules is we tried to clarify. So our same TA process isn't changing in any way, but we wanted to clarify the fact that if you've already been granted testing accommodations for the bar exam or the first year exam, and you want the same exact testing accommodations, that is going to be and still is part of the automatic approval process. There might have been confusion on the way the rules were drafted that says that applicants may request. And the change that was made is that applicants will receive automatic approval for the same testing accommodations as the state bar has previously approved. So I just wanted to verbally call that item out as well.
This is Robbie. Is anybody have any thoughts or questions? We've spent quite a lot of time on this, so I have lots to say. I don't want to take up too much of everyone's time, but I think we are certainly headed in the right direction. This is an evolving process. We've got to be cognizant of the fact that our accommodated applicant requests are close to 10% of our applicants. So for the July bar, that is about 1,000 applicants. And the idea is to level the playing field for all applicants and process those requests quickly and fairly. And I think this amendment to our process is a big step in that direction.
Can I follow up what Christina just said? So Christina, do they, somebody who has a previous accommodation, do they still have to formally just indicate they still want it, or will it be granted to them simply because the system knows that they previously received it without them having to take any action?
It is a checkbox when they fill out the application, the bar exam or the first year law student's application. It simply is a checkbox that says, are you requesting the same accommodations? And they check that box. No additional documentation is required. The state bar records have exactly what was granted, and that's where it becomes the automatic approval process.
Okay, thanks. I have other questions, but I'll let others go first.
And I should say, Paul, many applicants do not check that box. For example, a number of accommodated requests are orthopedic and short-term in nature. I broke my leg, I have a broken arm, I'm going to need more time to type or fill in. Well, if they're not successful on the bar and they're taking it again, they may no longer require that accommodation. They can take the general bar exam. So we do see a number of repeating applicants who don't make that request, which I think is why we require it. It may have been a temporary disability that is no longer preventing the person from sitting for the bar exam at a level playing field level.
Okay, are there any others with questions or comments? Let's see,
Yeah.
Ashley?
I think Alex was ahead of me.
Lady first.
Okay. Yeah, so I have a few questions. One is about the timeline. Have we looked into the cost that would be incurred if we were to increase the number of staff reviewing those accommodation requests to get to the point where we can meet those kind of suggested or requested timelines that the comments had asked for, as in, less than or I think it's 30 days or so. Have we looked into that at all?
Not to my knowledge. I have not looked into that. It is a short period of time right before the major bar exams, although there's also the legal specialist exam in the first year, but I'll concentrate on the bar exam. It's a very limited time, maybe 30 days, 60 days prior to that we would need additional support and help reviewing those testing accommodations files. The timeline, the committee, gosh, I think it was back in March, have made a motion that after 2 exam cycles with this new process, we'll be tracking to see how quickly we can review the files and get them to and from the consultants. And so we've made a motion there to come back after 2 exam cycles, and we have a little bit more familiarity with the new process, the updating of the applicant portal, the forms. And so we are still committed into looking at timelines there.
Okay, gotcha. And then what are the maybe this is something that's been answered, but what are the qualifications of the people that are doing the reviews of the initial testing accommodation requests from the outset before it gets to a professional or one of our professionals?
So it actually goes to a disability accommodations expert first step along the way. So unless it's automatically approved by staff, it goes directly to the consultant. Staff is not making any decisions until a report from the consultant is back.
Okay, great. And then as to the documentation requirements, are the terms that are outlined in there, and this might just be my missing it, but are those terms defined in the rule? I'm specifically looking at any kind of definition for individualized assessment or qualified professional.
I believe they're both in there, but I need to pull up the
Donna's
rules.
nodding.
Yeah,
Oh,
actually,
okay.
I believe it was you last time who requested that we add a definition of
Yeah.
individualized assessment, and we did that.
Okay, perfect. And then is this, I think this was also something that Paul brought up in one of the previous meetings, but have we also looked into what that means for updating the website as to the guidance we're giving to applicants?
I'm sorry, I missed that question. Can you repeat it, Ashley?
I'll take
Donna's
it,
got it.
Christina. There's going to be a significant overhaul of the website. Once we know exactly what it needs to say, as we finalize these rules, we've been sort of partially using these rules, right? We've started doing this automatic auto approval process for a lot of things that previously we had not done the auto grant. So we've been doing that, but we know until we roll out the forms, it's not going to be 100% effective, right? Because it's not, the forms will be are very clear in terms of this is what you need to provide. There will be instructions on the website that go along with the forms. Christina's team is also spending some time putting together something that makes very clear, this is what a standard exam looks like. Because one of the things that we find is for some number of applicants, what they are requesting, we get requests for things that any applicant would have access to. And then you've probably seen, this committee get into debates of, well, are we denying that? Are we, right? So, and it feels like we're denying a request that we're really not denying because everybody has access to it. So there's going to be a lot more information and a lot better information on our website. The forms, how to fill the forms out, what the standard, what would typically be allowed already, so that people can really focus in on, here's the thing that I'm asking for that I need in order to access the exam that I don't already have the ability just to get as any other applicant would. And I want to spend my energy talking about that and getting the note from a qualified professional talking to that those particular things that I need, not spending my energy getting information about things I don't. So there's going to be a significant overhaul to our website.
Great. Okay. I think that's the questions I have right now. Thank you.
Thanks, Ashley.
Alex Chan.
Thanks, Chair. So I echo the notion that we, as the CBE, in principle, just cannot automatically grant requests based on accommodations received during law school. And that's because California is a very unique state with many accredited and unaccredited law schools. But not every law school is created equal. Some have more resources than others, and not every law school has the financial or human resources to vet each TA request, which makes it really hard for the CBE to set a uniform standard for evaluating these requests across all the schools. And we know because we perform regular inspection at these schools. And so without a uniform standard that these schools can follow, it really falls on the CBE that Mr. Brody mentioned to vet each request individually, right? Basically an evaluation that is based on a number of factors. There is simply no one-size-fits-all solution. That said, I'm very sympathetic to all the public commenters seeking some kind of a reform. I know CBE is committed to creating a level playing field. I know Mr. Brody has spent a lot of time out of his own personal leisure and vacation just to find ways to resolve disputes, right? And in the last year or two, we now have an independent CBE panel to review any denial. And so with that said, on the issue of extending the 30-day deadline to 60 days, I certainly believe it warrants some serious consideration. And I asked the staff and Mr. Brody to make, to really try really hard to give the applicants, those requesting TA requests, more time to submit their applications. It is very stressful, extremely stressful if you only give them 45 days. Setting aside they have to prepare for an exam, but they also have to prepare their personal statement, have to get their doctors and all their psychologists a letter of support. There's just a lot of work involved, and so hopefully we'll find some kind of a common ground. Also, I want to mention one more thing, is that I'm just looking through all the commenters, and I remember the one that I read really sort of mentioned the point about the deadline they have to file for an appeal or to request for review. I think currently, Christina, let me know I'm not correct, but I think currently we only give them 14 days. Is that correct? To submit a request for a review?
So that is correct. Our current rules that govern us actually gives them 10 days based on public comments. Last a few months ago, we extended that to 14 days. It's state bar policy that we will go ahead upon request and grant an extension if they need to, the applicant needs to go to see a doctor or get more documentation in support of their appeal, but that's correct.
Personally, I think that's too short. 2 weeks, I appreciate the timeline that we have, but the public has spoken. It's just too short of a period for them to get together all the necessary documentation. And I certainly understand that they can request an extension. But again, that's just sort of another hurdle that we put in front of them to jump through the hoops to get to the place to request review. And so I certainly want us to consider granting or extending the deadline from 14 days to something further out, maybe 30 days. Again, I think we're just going to have to play around with all the deadlines between submitting applications, hearing, getting a response from us, and also moving for a request for a review. So that being said, I appreciate Mr. Brody for spending so much time and commitment on this issue. It's very important, without a doubt. And I assure you that this committee is doing everything we can to make sure that everyone, including those who are requesting accommodations, get an equal voice throughout this process.
Thank you. And Alex, I just want to highlight or draw to the attention, there was a recommendation in the agenda item of perhaps how we can extend the appeal process to 30 days. And that was based on a tiered system. Essentially, if you applied by the timely deadline, you would have 30 days. And if you were among the late people to reply right on the final deadline, you would get the 14 days. Would that interest you? Or are you looking for something more? Or can you give me your thoughts on that?
Yeah, the tier system certainly is reasonable in the right direction. But again, I want to be careful that there are certainly going to be circumstances where the applicants, they could be late for a number of reasons, right? The reason why they're requesting accommodations could vary from one individual to another. There could be, going through or continue to go through traumatic events. I can come up with all sorts of reasons, but that being said, the system is the right direction, and I would hope that the public commenters would will give us some more guidance. Is this enough? Do you think this is do we strike the right balance? Things like that. I certainly would welcome any comments from the public on that. But for me, I do think it is the right option in the right direction. Should we do more? I certainly would ask that we do more if we could.
Anyone else? Okay. I'll note that I don't think anything prevents somebody from filing their TA request much earlier than the last day we allow them to. Christina, you spoke to most of the questions I wanted you to address because of the comments we received this week. But the one I didn't hear a response to was what happened with regarding the comments that are said to have been lost in the commenting portal.
I need to turn this to somebody else because I don't know about that.
Yeah, I can take that. So we received some emails indicating that individuals had submitted public comments that were not initially on the public comment chart. So we had I apologize. We had a Public Records Act request for all of the public comments that came in. And so the requester and others looked at what was on there and identified some individuals who they said submitted comments through the public comment process and those weren't on. So we went back and looked for the names that were identified, and one of the individuals, in fact, in her own email had specifically indicated that she submitted public comments in response to the admissions fee proposal and the cost reduction model proposal. And that was exactly where her comments were. And they weren't, and so that's why they weren't on the testing accommodations chart because they were submitted for a different public comment opportunity. There was an individual who spoke who had submitted, as she indicated, submitted an email, and we had that email, and so we added that onto the public comment. We have no indication that that the system is faulty, that people did in fact submit comments through the public comment chart process, the public comment process that were not received. And we do, as I said, we found some in response to other public comment opportunities or through emails, but no one else who we were told, you know, this person indicated to me that they were going to submit a comment. None of those individuals did we find any reference to them having submitted a comment through any of the open public comment opportunities. And we didn't hear, there were one or two names, I think, on that list, and we didn't hear from them either specifically that they did submit a public comment. So we don't have any evidence to suggest that the system is not putting the comments where they are submitted. What we did do was offer certainly to those individuals who thought they submitted comments, but ended up luckily having submitted an email, offered a staff representative next time there's a public comment opportunity to reach out, and staff will help them through the portal in case there's some difficulties that some people have in using the portal. So that's sort of the best that we think we can do at this point, because we are not aware that there were any comments submitted that did not come in through one of the public comment opportunities.
Okay, two technical questions. The rule speaks to giving the notice of the bar's decision on the request, quote, in writing. My understanding is that you're really intending to use the applicant portal, so you would write to them via the portal, and I gather the portal then sends them an email saying you have a message. Do I have that correct?
Actually, Paul, I don't think that is correct. That isn't correct. We do email applicants their final decision letters, their testing accommodation notices, while the applicant may submit their documentation on the applicant portal in order to confirm a decision or ask for more information that is emailed to applicants.
Okay, well, but it's not in writing to me, maybe because of my age, means reduced to paper and sent to them in the mail. And you're not doing that. So I think what we did in the case of the moral character rules recently was we made it clear that when we say in writing, we can transmit it electronically. Do we have a similar provision in these rules, or is the provision that makes that definition a generally applicable provision that would apply to this?
So that was under the general admissions rules, the definition of receipt by the state bar, and by an applicant, we included the electronic transmission. So I think that would cover TA as well.
Okay, well, I'll leave that to council to figure out. But and then finally, first of all, there's one more after that. But the revised rule appears to assign the consideration of all appeals to the exams subcommittee, even if in the current case, we only send things to them if there's not a CBE meeting that is appropriately timed to be able to deal with the appeals. Is it the intent to have the exam subcommittee consider all of the appeals? And before you answer, I'll tell you I have no problem with that. I'm just wondering, for the sake of clarity.
Yeah, we had discussed having more frequent subcommittee meetings than actual full committee meetings in order to keep the timeline of decisions communicated to applicants moving, rather than only holding the decisions, at least as far as appeals are concerned, until after committee meetings, full committee meetings.
Okay, well, I'm fine with that because frankly, if I had my druthers, I would have gone with the original staff proposal that we no longer consider those and we just occasionally audit to see if things are working correctly. So it will save a lot of time in our meetings of the full committee if the subcommittee does all those. I wonder if the subcommittee is going to have the bandwidth to be able to do that, because that will mean meeting probably several weeks in a row prior to each exam. But I'll leave that question in the air. My final question is, unlike Robbie, I don't have an intuitive appreciation for how many appeals or how many requests, TA requests are granted as a percentage of the whole of the requests. He believes that most are granted. I simply don't know, and I'm wondering, Christina, if you have a sense of that you could share. Do you keep statistics, for instance?
We have pulled those numbers before. I apologize that I don't have them in front of me, but we can probably bring those back unless someone pulls them.
Remember
But
what the last few was?
I can tell you that the majority of the requests are granted.
Okay,
I can't tell you percentages.
Okay, anything else from anyone? Is there a proposed motion? And I think we need to be clear about, there's a couple places where there are options. Which of the options we're considering?
So the working group really thought this was important to bring back to the full committee for discussion, so everyone had a voice. As Paul, you mentioned, there are a few options before us. If we make any changes to the proposed rules, we should go out for another public comment period for 45 days. And so I give it back to the committee.
Well,
Well, can you describe briefly the nature of the proposed changes, Robbie? Because I have to believe there's some wiggle room where if we make a change that's within the scope of things we've been discussing for so long, that we shouldn't have to go out for another public comment period.
right, Christina, if we go with the proposal, which I support, which maintains the rule that's modified is we are automatically approving those testing accommodations up to 100% additional time if previously approved by another high stakes exam. That's the third of the three proposals, and that is certainly the one that I think that Dr. Cow and I support. Would that require, maybe Jean would know, would that require that we send it out for another public comment? We're really enhancing it, not.
Yeah, so we talked, Gina's smiling because we talked at length about this. And my personal inclination, Paul, is with you, but that's not what our rules say. We are going to be looking at changing the rule, frankly, because as you say, this is something that is sort of implicit in what we've been talking about. My personal belief is that the rule discourages us being thoughtful in response to public comment, because if we make any change that's substantive, largely we have to go out for another public comment. We appreciate this committee's willingness to nonetheless make the changes, go out for another public comment. What we are able to do in this instance, however, is due to the nature of the delegation, the delegations that the board has made to the CBE in various areas, and the fact that we're looking at a third public comment here, we feel comfortable that this committee can authorize sending it out for that third public comment without having to wait to take it to the board to get that authorization. This way, if we do that, we may be able to package the final result to the Board of Trustees in November as we had originally planned.
So come back to us in October.
So Donna, let me just make sure, I want to assist the applicants here. I don't want to make it worse. I think that the proposal that allows for an additional automatic approval is worth having to do another public comment period, because I think that ultimately is going to benefit a fair number of our applicants that have previously required an independent review that slows things down. And in turn, it should speed up the review for other applicants who are not similarly situated. So I don't want to say, then let's just go with option number one, which is no changes, so we don't need another public comment. I don't think that considers, the thoughtful comment we've gotten for today, which is why I want to go with that option. Do you agree that we want to assist in accelerating the process?
Yeah,
Fair.
absolutely. That's consistent with the staff recommendation that was included in the agenda item to extend the automatic approvals to people with up to 100% time. And I would I would not be inclined to change that policy decision based on a sort of formal requirement that we go out for a rule change. I don't think that's a good way to make policy. So
Okay, then I don't know, Christina, can you put that on the screen, the third option, which provides for an avenue to give an automatic grant to those situated applicants?
Situated how? It
The-
occurs
well-
to me that if there's some interest in maybe also accepting automatically school determinations on the part of some. I know that you're not recommending that, Robbie, and I'm not, frankly, but maybe we should also put that in the package as an option so that we can.
I just want to remind you, Paul, and the committee, that the language says that great deference, I think, is how is given to those. It's not discounted, certainly. It's part of what is reviewed, not only, by the bar, but by the expert. It's just that it is not determinative. So I don't know if there's a way to split that baby. I don't think you could say.
I'm not saying I would not vote for it, but to accommodate the will of the majority, if it were to go that way, and avoid another round of public comment, I think we should. I'm seeing this as a lesson for our future. We try to draft things so that all the options are on the table, and then we decide what we want to choose them from among those options. But rather than try to work our way to a particular outcome by manipulating the process, if you will.
Well, I would propose then the motion that I'm proposing on behalf of the subcommittee. And if it does not pass, then, Paul, we can look at other options, including law school approvals as being a default for the bar. But I'd rather go one at a time. And if it doesn't get sufficient votes, then we'll move on to other options. I think that's the way we usually do it.
Well, I'm just saying, learning from what's just happened here, that if there is any interest in considering accepting law school determinations automatically, that we'd be efficient to put that in there as an option, so that when it comes back again, if a majority wants to choose that, they're able to.
But I think, Paul, if I can be clear, I think the reason we're having to go out for the third public comment is because we're making a substantive change with the recommendation as presented in the agenda item, either the change to the law schools or the double time automatic approval. So I think that's why Robbie's trying to go with the one, because I don't think we can go either or out for public comment.
Oh, I hope we should be able to. Somebody needs to look at that rule because I think it's unduly, the rule, the standard for when we have to go back out to public comment. Because I think that as unreasonably restricting our ability to do business and make decisions. And if it's a rule of our own making, we have the ability to, to fix it. But that's another action item. Okay, I guess maybe the first question, Robbie, is anyone interested in automatically accepting law school determinations? If nobody is, then I'm wasting my time and yours. I'm not.
Okay, well, I don't see any hands up, so
Never mind.
again, I would like to see if you can put that up, Christina. I really hope CBE members, we're going to have to, see, but I'm really hoping that this is going to open the pipeline for a smoother process for all applicants by making this, it seems small, but it's really, it's a good percentage of the requests that we get. And it will be nice to know that if those requests were previously approved for a high stakes exam, it's just going to sail through without the necessity of review, which is time consuming. So I don't know, will anyone make
This is Robbie, this is Michael. I will go ahead and second your motion, Robbie.
Okay, Paul, are we allowed to move and second the motion?
I don't think there's any prohibition on, well, actually, you're just a member of the working group. You're not even a subcommittee chair, so.
Okay, then you have your motion and your second.
Okay, motion Robbie, second Dr. Cal. Any further discussion before we vote? Hearing none, Devin?
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes,
Alex Chan,
No.
Jim Efting,
Yes.
Kareem Gangora, Dolores Heisinger,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak,
Yes.
Ashley Silva Guzman,
No.
Vince Reyes,
Yes.
David Torres,
Yes, ma'am.
Paul Kramer,
Yes.
back to Kareem. With 9 yeses and 2 nos, the motion passes.
Okay, thank you. In LA, Robbie, the two gentlemen that are with you, I believe they spoke this morning regarding People's College of Law.
Correct.
I just wanted to let them know if they were expecting to make more comments when that item is going to be heard later this afternoon, they would not be. I don't think they're representatives of the school. And so if they're just hanging around to do that, I just wanted to let them know. Okay.
Oh, thank you. We're just here to observe. Thank you.
Okay. You're
They're
welcome.
just so thrilled and interested in what we're doing. That's why they're here.
They sell them a t-shirt or something.
Okay, this again.
Let's see, I think we're on to operations and management. The cost, bar exam cost analysis. So the next item is discussion and action on the refund of fees policy for examinations. Tammy?
Okay, Viviana, can you share the PowerPoint, please? Okay, so with the past 2 CBE meetings, we've been discussing the refund of fees policy. Next slide. Just as an overview again, the areas that we were reviewing over these past 2 prior CB meetings was the exam application dates and deadlines, examination attendance policies, withdrawal of exam applications, refund of fees policy, of course, and then we also had the rejected payments policy, which was approved at the June meeting. Next slide. At the June meeting, there were items that we discussed and were able to come to a determination with, and that is listed in the agenda, but I'm also going to review it here on the PowerPoint. So the one of them was the flat fee penalty for no-shows. And those were applicants who are no-shows are not allowed a refund of their exam fees. So the determination was made that there would be no additional penalty fee assessed to those applicants. We discussed credit card processing fees. Bank fees that are charged to the applicant by way of using a credit card are not fees that the bar keeps. So the determination was made that we would not include those in refunds to applicants. We specified that the definition of immediate family members would be able to be found by looking at the California Family Rights Act. So that way there's guidance on what justifies or defines, I should say, an immediate family member. Next slide. We talked about ACH e-check payments now that we are using that format for payments, that we added language to reflect the new rejected payments policy that was approved at the last meeting. We also discussed the 90-day deadline to submit refund requests and then added the language that there is a 90-day deadline to request the refund for the death, serious illness, or disabling injury policy, but that it needs to be from the first date of the exam when that 90-day period. Next slide. So the one area that we were circling back around this time to discuss is with regards to the refund under the death, serious illness, or disabling injury policy. The statute does require that a refund is made to an applicant if they've taken the bar exam or not taken the bar exam due to death, serious illness, or disabling injury. The statute does require the refund to be in the amount of fees paid for the bar exam, including filing fees less administrative costs. We currently have it set at a 95% refund to the applicant. And the CBE at the last meeting requested for staff to look at the following 3 areas and to bring it back in August for review. That was trying to find a specific definition of administrative costs. We also were asked to discuss further with finance to determine if they were aware of any rules or anything that would define administrative costs, as well as identify if there are any other state bar rules or statutes that provide guidance on what an administrative cost could entail. Next slide. So the discussion with the State Bar Office of Finance determined that they were not aware of any specific statutes or rules that would be able to help define what administrative costs would be. I went through and looked at a lot of our rules that we have in place at the State Bar, and I did find there is one rule, Rule 3.251, that does provide that participants in the Lawyer Assistance Program are responsible for all expenses and may be charged a reasonable fee for administrative costs. However, with further discussion with one of the employees in the Lawyer Assistance Program, we were able to identify that one, there is no definition for the administrative costs, and that the Lawyer Assistance Program has never assessed such a fee, so the committee is not going to be able to gain any insight from this rule. The other area that we spoke with was the Office of Access and Inclusion, to see how they handle anything with regards to administrative costs in their in grant oversight capacity. They did consider administrative costs to be any cost related to running the program, and with regards to grants, they would consider administrative costs to be the cost that commence from the start of the grant to the end of compliance. So that's the background we were able to get with from the Office of Access and Inclusion with regards to the grants that they work with. Next slide. We looked at some other various statutes under government codes. One code we found provided guidance under section 11270 about general administrative costs. with reference to like legislation and other agencies. And they define that is the amounts expended by legislator and proration of any other cost to or expense of the state for services or facilities provided for the legislator and the above agencies for supervision or administration of the state government or for services to other state agencies. So we continue to try to see what we can do to pull together. We're getting a little bit of a variation, but we're seeing similarities across the board. Another area of research is I looked at other government agencies, all variations across the whole United States. I was looking at various schools and various different agencies. And one of the things that we found was that although none of the government agencies were able to provide me any definitions, we were able to see that they based it on similar work or conditions that admissions is seeking a solution for. There are differences from what we do with other agencies we looked at, but a common theme was that was helpful was the distinction between direct cost and indirect costs, both being components of administrative costs. Next slide. The closest comparison that could be found was with the federal definition with the U.S. Department of Education regarding an administrative cost cap on grants. The document did define that administrative costs are those that encompass grant expenses associated with administering the grant. These costs could be both personnel and non-personnel and both direct and indirect. Therefore, the limitations apply to the combined claims for indirect costs and direct administration costs. Next slide. So after the review of trying to identify what administrative costs definition would be and not really able to really find a solid definition, but able to tie in all these various different areas of the bar and various other government agencies and rules and statutes, we were able to kind of see that we're already talking about direct costs, indirect costs, the personnel. But with regards to how we've been doing things with such as the February 2023 cost analysis, we're always limiting the cost analysis to just the direct non-personnel costs of the exam, which of course is facilities and tables and chairs and electrical and all of those aspects that we are putting on the exam on site. Now below, again, we talked about that during the February cost analysis. I wanted to just be able to provide some kind of a range for you to see, and that is to see the administrations before the pandemic and the administrations after a pandemic on how the cost per applicant is working out over this time period. And you can see July of 18, it was an overall $255 per applicant overall. And now February 2023, $679 is what we just had for the February bar exam. So just to give you some context from before pandemic to after pandemic, how our costs have been, looking at it from an overall cost per applicant. Next slide. And so based on all of the information that was obtained, it does appear that administrative costs should be any expenditures leading up to the exam for an applicant to sit for the exam. I wanted to provide a little bit more context with regards to percentages, because I know there's been the 5% we're already doing. There's the 80% that was put out there. There was also a recommendation of a minimum of 10 to 20%. So for the committee to be able to see this range based on a $677 general applicant fee, this is what it would look like for these various percentages on what the applicant would get versus what admissions would retain. So of course, previously referenced 5% is $643.15 to the applicant, to the admissions office, $33.85. And then to the other side, 80%, applicant would get a refund of $135.40, and admissions would keep $541.60. And you've got all those numbers in between to show what those differences would be based on percentages. So after the review of everything to try to come up with what would be the best way for us to approach this, the staff's recommendation is to provide a 50% refund of fees to applicants for a death or medical emergency that has occurred after submittal of the bar exam application, but before the exam is administered. Next slide. So based on that information, this is the motion that we have at point right now, which is to move that the Committee of Bar Examiners approves the proposed revisions to the refund of fees policy that was set forth in attachment B. Based on that, if there's anybody who would like to make the motion and second it, we can open it up to discussion.
Doris, I'll move.
And this is Robbie, I'll second.
Okay, it's discussion. Anybody have any questions or concerns?
Nothing here.
Go ahead, Jim.
My concern is that the motion references a document we don't have in front of us. And I just don't like doing that. I think we've got to have both the exhibit and the motion in front of us.
Is that not an attachment?
I didn't see it. It wasn't in front of me, at least on the stage. And I couldn't find it when I looked for it on the computer.
Viviana, can you stop sharing the PowerPoint so I can share the policy, please? Okay. You guys able to see my screen?
Yes.
Okay. Now, if I can only get my screen to not show me everything else that I'm seeing. Okay, so at this point, this is the attachment B, which is the clean version of the refund of fees policy. This encompasses all language changes we made as far back as April. And it is also showing all of the updated things that we approved, such as no credit card processing fees in the refunds, 90-day deadlines. This includes everything. So when we look down to the death and serious illness or disabling injury, it's already built in based on staff recommendation for the 50%. So at this point, if there's discussion with regards to that or any other aspects of this refund policy, we can look at this now with it on the screen and review everything and discuss.
Tammy, just for clarity. So in the posted agenda item, this is the clean version that Tammy is showing you is found on starting on page 15 of 18 in the agenda item.
Thank you, Donna.
That might have been the confusion, Jim. It's not an attachment. It's all part of the same document.
Yeah, I think that's partially because of me. I complained when I had to download 3 or 4 documents when they could have all been combined into a single PDF. Anyway, my question, Tammy, is how does that 348 or whatever it was figure, what tally of costs does that equate to?
So again, just basing it off of the same areas of cost that we always provide in the cost analysis. Anything leading up to the exam, but it would not include anything for grading. We're not looking at MBE scores being, any MBE Scantrons being scored, because those are the fees that we don't pay to be done if an applicant does not sit for the exam. And other than that, it's just based on the percentage. It was trying to come up with some percentage that we can put out there and say this would be somewhat of being compassionate for the applicants, but at the same time looking at what it is that we're putting out in cost prior to the exam. Of course, you know, putting out the cost prior to the exam is more than going to be more than what we're going to collect in the 50%, but wanting to make sure we are being compassionate to applicants, but at the same time looking at 5% is probably not enough at this point in time.
Oh, clearly, yeah. So we're basically, as we appear to be going to do in the case of exam fees, not recovering the full amount of what we expended from in the name of compassion. Yeah, I'm okay with the 50%. I just don't want anyone to ask me to show them the math about how we got there, because it would seem to be that what we could do is total up the expenses we don't make, which would be grading, some amount of staff time for grading, the license fee for the multi-state, the grading fee for the multi-state. And we really can't, at the last minute, we really can't reduce our commitments for tables and chairs and testing center space. So those are probably the amount. And I suspect if we were trying to fully compensate ourselves, it would be more than 50%. But you know, it is an ever varying math problem as your different numbers over the different tests illustrated. Okay, thanks for that answer, Vince.
Yeah, Paul. You know, I thank the staff for this. I generally support this and see that you're basing these numbers on static expenses. But what if somebody raises? Can we do this pro rata? For instance, my traumatic experience happened a week before the test. Shouldn't I be getting more back? Or, you know, has that argument ever come up?
Say that one more time. I just want to think about what you're saying a little more.
Yeah, if someone might say, well, why aren't you doing this pro rata instead of just across the board?
Sounds like you're talking about a sliding scale where you get less back the closer
Yes.
you are to the exam.
Yes, I mean, I agree with this, but you know, that could come up as a reasonable argument.
So I know we discussed this last time. I think it was brought up, I mean, possibly by Alex Chan, about looking at it on a exam case basis. Each exam is going to cost a different amount and basing it on that. But I do think there are complexities to how that would transpire by trying to do it by each exam. These applicants are requesting for their refunds. It would take a little while. It takes us probably at least 2 months to get all of our invoices paid. You know, as soon as we get them, we do process them, but some of our vendors, it takes longer than others. So you're looking at, if we're trying to give a refund to an applicant based on what we spend at any given exam, we're looking at least 2 months before we really know what our final costs are for that exam. And I think that poses a difficulty in being able to quickly give an applicant a refund based on doing it on that aspect versus saying this is the percentage that we'll give if there is this circumstance.
Yeah, thank you, Tammy. I'm good with that. I just wanted to make sure that we can defend it because that argument might come up.
But Vince and Tammy, I just want to also point out that we do have a withdrawal policy where if you withdraw within a specific amount of time, you're eligible for either 30%, 60% of your exam expenses. And as you get closer to the exam, then you're not eligible for any refund. So I just want to draw that we do have that separate and apart from the proposal that we're talking about here.
Oh, okay.
Yeah, and so
But that's for a voluntary action on the part of the applicant, not an illness or something they can't control.
Yes, and sometimes they're one and the same. That somebody realizes like I suddenly have this condition, I'm not going to be able to come to the test, so they voluntarily withdraw. Yes.
And the fact that we do base it on after they've submitted their application, but prior to the exam. So technically, if they submitted their application, let's say for the July bar exam, the application opened up on March 1st, March 15th, they submitted an application. On April 15th, something happened. there is the window to withdraw and get a refund based on withdrawing versus using the refund based on a death or a medical emergency. But the death or medical emergency has been 95%. So they do end up with more of a refund if they do it under that versus withdrawing for the actual exam. So that would be a little bit of a difference there. Yes, they can, but there's a larger percentage if they do it under the medical and death and versus a withdrawal.
Okay, Jim?
My problem still exists with the paperwork here. How are we gonna put in the minutes that we passed basically a policy on attachment B that's not part of the minutes? So are we gonna attach B to the motion or what? That's my question. How's it gonna show up in the minutes next meeting?
Did we reword the motion, Tammy?
Reword the motion.
Instead of just referring to an attachment to referring to the policy.
Okay, well, I guess we could reword that to say the refund of fees policy that was in attachment B. I'm not sure what the right way to do that is. That's not something that I've
Attachment
ever
B is
done.
defined in the staff report. I mean, it could have used maybe an attachment B label where it began in the PDF file, but we don't normally put the full language of an amendment of, especially if something that's relatively long like this, into the minutes, do we?
Not that I'm aware of, but I'm not the minutes secretary. So Devin, do you put this amount of detail into the meeting minutes when you put it together?
I can. Yeah, it's not an issue.
I mean, I'm not trying to make it overly burdensome, but I want to be able to read later what we did. That's all my concern.
Yeah, you just have to go back to this agenda item, you know, which will be up on the website, I guess. Well, who knows, with storage being an issue.
So shouldn't we just modify the motion right now?
To maybe attachment B, proposed amendments to exam administration. I can't read the rest of it up there, Tammy, but with the attachment B title.
Hold on, let me reshare.
If necessary, I'm amenable to a friendly amendment to the motion itself.
Thank you, David.
If you also want to incorporate it by reference, you might incorporate the pages of the agenda item into the motion. So you could, instead of having attachment B, say pages 15 through 18 of the posted agenda item.
That works great.
Thanks, Jim.
Those are the
Okay.
So moved.
So before we move
So
that,
amended.
can you guys repeat that? Because I've been trying to pull the motion back up. So if you can tell me real quick, I'll put it in and then I'll reshare the motion for everybody to see and agree upon. So you want us to say revisions to the refund of policy set forth in
Pages 15 through 18 of the agenda item. And if you put it up, I can tell you if it reads correctly. It's
okay. Let me just dial it in here on my side. And all right, let's see if this works here. All right. So this is what I have on the screen for you here. Refund of fees policies set forth in pages 15 to 18.
But I think you want to add at the end of the agenda, after item, say the PDF file, because literally the pages in the file are numbered 1, 2, 3, 4. Just to be clear.
so Tammy, after agenda item, put III.A. Large I's, sorry.
All right.
And you can put in parentheses PDF file.
Can you also put the date, August 2023?
Isn't that reflected in the fact that the minutes?
I'm not understanding this at all. The attachment B is in the agenda item. It's listed at the end of the item under attachments, and then it's there in the agenda item itself. As you scroll down, the attachments are there. So we seem to be spending a lot of time wordsmithing this, and I'm just not understanding that there's actually a change that needs to be made.
Yeah, it's
John-
just a cul-de-sac.
John, I think the confusion is that it's not labeled as attachment B and it's not bookmarked. And so I think Jim's concern is that it be clear what they're adopting. So I was just trying to clarify that.
Okay, and just to make it even more fun, it's actually attachment C is what we're now referring to, not B. B was the underlined strikeout version, C is the clean copy.
On the agenda item, I just downloaded the red line is attachment A, Paul, and the attachment B is the clean.
Oh, you're right, okay, sorry. Never mind.
So do we want to leave this motion as it is on the screen right now, or do we want to go back to attachment B?
That's fine the way it is.
Okay. And the actual refund of fees policy does reference it being adopted by the committee on today's date. So I don't know that we need to add August to the motion unless somebody thinks otherwise.
I'm happy.
Okay, so then if that's the case, then this is the motion that somebody, I don't know if we need to motion and second again or not.
Mr. Torres, you agree to this friendly amendment?
I do.
And who seconded, Mr. Brody?
Yes, and I do too.
Okay, Devin?
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora, Dolores Heisinger, Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak,
Yes. Dolores was a yes, I just couldn't unmute.
thank you. Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Paul Kramer.
Yes.
With 11 yeses and 0 nos, the motion passes.
Thank you. Let's see. That was all for operations and management. Let's go through a couple of educational. Well, maybe this is the time to ask. People will start to need to leave at some point, hopefully not immediately, but let's see. If we have no time for the closed session, we have a couple of moral character appeals, and O&M appeals. When does, God, I'd like to be out of here by 5. I was hoping for earlier, but does anybody have to leave earlier than that? Okay.
Yes.
When?
I gotta leave by 4:30 today.
Okay.
I have to leave by 4 today.
Okay. We'll still have a quorum, I think.
We will.
I would like, could we do the report from director next? Audrey?
Well, I
Let's
think
just
we
see
have a
what
lot
you
to
want to
go
talk
through
about.
in ed standards.
Right, that's why
Oh,
I
we
want to
could.
make sure that I get your thing, especially with respect to our outgoing members.
Oh. Okay. Ping me when you have 15 minutes left and we'll do that if we haven't been able to reach it. Okay?
Okay.
Okay. Let's go back then and continue with educational standards. Action on the 2023 MPR, minimum cumulative 5-year bar exam pass rate compliance reporting. Natalie, in the interest of time, could you maybe just give us the quick highlights of this report, which we have had before us?
Sure. Yeah, I'm happy to do that. So if you look at the item that's posted, you'll be able to see what the NPR scores are generally. I'm going to just briefly share my screen. The ultimate motion is going to be to accept these values that were verified by the schools, and under a separate cover, we will address San Francisco Law School and the appropriate action. San Francisco Law School is the one school that did not report an NPR above the minimum 40%. So just quickly as a reminder, all of the accredited schools only are required to earn a 5-year cumulative 40% bar pass rate. Unaccredited schools show a non-binding pass rate. This chart has only the regulatory number, and this is generally posted on the admissions webpage. You see an increase in the most recent years, and in part that may be due to the change in the cut score, as well as the addition of those who were able to license without taking another bar exam. When those changes were made, the NPR was not, and those additions to licensure may have boosted the NPRs. In the motion, one thing we'll also suggest, this was discussed all the way back in 2018 when the NPR returned, that perhaps when a school was in compliance, it might be helpful for the committee to send a specific letter to the school, letting them know if they were approaching the 40% minimum yet fully in compliance. At that time, a 50% number was suggested. Here, staff is suggesting any under 45% should be issued a letter, not a notice of non-compliance because the schools are in compliance, but just asking them to pay special attention. And that's suggested for University of West Los Angeles, 43.5% NPR, and JFK School of Law at National University, 41.2. They successfully came off of probation in a prior year, but they have stayed in the last 3 years very close to that number. So it's important for them to continue to focus on it.
Hey, can you put up the motion?
Sure, I'm going to ask Devin for help with that. It's in the other PowerPoint.
Sorry, give me one moment.
Any questions while we're waiting?
Okay. There we go. Can you see it okay?
Yes, thank you.
I would say, Natalie, the only thing that doesn't really reflect is the standard for future letters that might be sent out. It doesn't really hint at it. And you said it was less than 45%.
That's what staff is recommending. This is a new suggestion for your consideration.
Right, but if you want it to be reflected in the motion, shouldn't we say it more clearly?
That's totally up to you. You can view this as an experiment. These two schools were much closer to that, or we could add that wording. Just that this would be sent to any school with an NPR of 45% or below.
Okay. I thought you were just asking us to set a policy, so that's why I asked, but I'll leave it to the maker of a motion whether they think we can wait to make that clear.
I had to make, just Jim Efting, I'll make the motion that's presented to us now. I like the way it's presented. We can talk about changes later if we need to.
Okay. Is there a second?
Morris will second.
Thank you, David.
You're welcome.
Any further discussion or questions? Hearing none, Devin?
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora, Dolores Heisinger,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Paul Kramer.
Yes.
With 11 yeses and 0 nos, the motion passes.
Okay, next action on conclusion of probation and application for registration as an unaccredited distance learning law school, San Francisco Law School.
Yes, so, oh, sorry, Paul.
No, go ahead.
I thought I would start by putting up the motion. And Jim, do you have any comments to make before I give the brief staff presentation?
No, may have something afterwards, but not now.
Thank you. Okay, Devin, could you put up the next motion, please, for San Francisco Law School? Okay, there are 3 pieces to this motion. San Francisco Law School has not reported a compliant NPR since 2020. So the committee placed them on probation for 2 years, but at the end of those cycles, they did not return to compliance. Last year, the committee gave an extension of 1 more year. The school is still not in compliance. So there are 3 parts to this motion. First, the school asks for another year of extension to probation, primarily to avoid prejudice to their students and allow them to graduate from a school that would provide an accredited law school degree. Another option for them to do that would have been to return to compliance. Unfortunately, that was not possible. The students have known for several years now that the school could potentially lose their accreditation. And if they stayed, their degree would be the character of the school at the time of graduation.
Let me stop you.
Sure.
Devin, that's the previous motion. We're on.
It's the next one.
Oh, yeah, just one more.
One
There we
more.
go.
There it is.
Thank you. So the staff recommendation is not to grant the further extension. So far, the extension has not proved helpful to this school. And this school is not a small independent school. It is owned by Aris Educational System, further owned by Bertelsmann, a large conglomerate in Germany. They do have significant resources at their disposal. You heard earlier from some individuals who graduated from the school, but they did so back at a time when the school was in San Francisco. It owned its own building. It was community focused. Since that time, the school has sold off its San Francisco real estate. It has largely located its back-end facilities in San Diego. The dean has moved out of state. The campus has moved out of San Francisco. And part of the application today is to take the school to a fully distanced posture. So it's a very different school than what was described previously. So staff recommendation on the extension is to deny. Second element regards the school has asked that if the extension is denied, they ask that if any of their students decide to transfer, that the accepting school need not consider those students' results in their NPR. Staff recommendation is to deny. Every school should take responsibility for every student, and every school should educate its students to a level to which they are comfortable putting them forward in a transfer. This would change a very fundamental regulatory measure, and staff does not see the need and sees many cons to accepting this. So it's recommended that that motion be denied. And then finally, the school requests to move to unaccredited distance status, keeping their headquarters in Emeryville, but having their back-end support services located in San Diego, but accessible from the Emeryville campus. It would be helpful to understand more about the staffing plan given that some of the administration has moved out of state. But other than that, the application does touch on all elements, and the redesigned curriculum does correctly include the correct amount of hours each year for 4 years, including not only the overall distance hours, but the interactive synchronous hours that are required of every distance school as well. So staff recommendation is to grant. So staff recommendation in summary is to deny the extension, deny an exclusion of NPR scores for transferring students, but accept the school's request to reopen as a registered, unaccredited distance law school effective today.
Is there more to this motion? Because I don't see the NPR exclusion denial.
Let's see. We can place that in.
While she's doing that, does anyone have any questions or comments?
Yeah, I have a question.
Vince?
Natalie, could you remind us again of what were some of the efforts of the school regarding academic assistance?
Sure.
I'm just, because, you know, it's been like 2 years, right? And I just want to make sure that maybe they were trying, maybe they were not trying.
Yeah, so a number of things. When the school was last inspected, and Alex Chan was a part of that inspection team, at that time, the school was significantly under-resourced. So to bring it back to a minimum level, the school added significant administrative resources. And then to exceed that level, they added a coach, they added a full-time registrar. The coach was focused on state bar exams. They redesigned their curriculum. They also added a special bar prep program for alumni who were returning to take the exams, separate from the bar prep resources offered for the students. Additionally, they stopped accepting new students to completely focus on the students that they had. At this point, they have only 5 students remaining, and they are all 4Ls. And so this will be their final year in law school. So on the one hand, the efforts are admirable, but on the other hand, the outcomes are not what one would expect, given the amount of resources the school had and the small number of resources. We do have the dean here and also the provost, so it might be helpful while I add the additional paragraph in here to take the 5-minute public comment period from the school, and then we can continue the committee's discussion, which would be standard procedure.
It would be, yes. Thanks for the reminder. Dylan, do you know who to add?
Yes, so that would be Tim Weimer and Tracy Heller, please.
Okay.
For a period of 5 minutes of public comment. And because I will be adjusting the motion, I would ask if Viviana and Devin could please watch the time, which I usually do.
Good afternoon. This is Dean Weimer from San Francisco Law School. And as Natalie had mentioned, Provost Heller's here if you had further questions specific to the university. I think we've reported every 6 months has been requested of the improvements that we have made from the time that Dean Van Tassel and I arrived in 2018 until today. We have made improvements to our program incremental each and every semester just within the program itself. We have committed a large number of resources over the last 2 years to help improve our bar pass rates, including the programs that we've mentioned for those who are alumni of the school and are returning to take the exam. That includes one-on-one tutoring with our professors. We have essay writing workshops that meet once a week with extensive feedback and review. We have an MBA workshop. We have an online MBE library with over 300 question and explanatory answers, along with offering AdaptiBar resources to our alumni. Those are just some of the things we've added over the last 2 years to assist our alumni in preparing for the bar exam. Included in our application to become a registered unaccredited law school is our revised curriculum, which we had planned to roll out 2 years ago, but that's when we chose not to accept new students. The new curriculum, as explained in detail, is designed to really address what we felt were maybe some shortcomings from the program previous to my time. That program is what any new student is going to have coming into the school. So as far as anything that we have done, we have been open and transparent and reported to the state bar for the last 3 years, particularly in annual reports or in the semi-annual reports after we had our inspection back in 2020. I do want to remind everyone that we are 100% in compliance with everything else. We have struggled with this bar pass rate, which we continue to put resources in to try to help those who are graduating prepare for the bar exam. Just speaking to my most recent graduates who took the exam in July, they came out much more confident than any group I've worked with since I started here 5 years ago, but we have to wait for another few months before I have those results as well. So it's all in the reports we've sent. We feel we have dedicated a large and a good amount of resources to trying to address this one issue. It hasn't resulted in the immediate turnaround we'd hoped for, but we'll continue to improve things as we get feedback after each and every round of the bar exam and as we roll out our new curriculum.
Good, thank you. Do we have any questions for either Natalie or Dean Weimer?
I do. So Natalie, if we take away their accreditation, they can reapply for accreditation at any time?
Yes, upon demonstrating a 40% or more NPR and the other requirements for accreditation, they can reapply for accreditation in the future.
Okay, thank you.
To wait a certain period of time though, or have a, like have 5 years of compliant NPR?
There's not a minimum requirement of time. The committee may place its own conditions, but right now there's not. But as a practical matter, it probably would take the school a period of time to reach a compliant NPR, particularly considering that it had been out of compliance for 4 years. The school was on an accelerated inspection schedule already and was due for an inspection this year, but because of the NPR related issues, that was held in abeyance by this committee. So I would expect that just naturally it would be a period of years.
Mr. Chan?
Natalie or Dean Weimer, what's the current size of each class? I think Natalie, you mentioned 4 students for 4L, but what about 3L, 2L, and incoming?
So they actually stopped admitting students when they were placed on probation. So they have a total of 5 students across the school. They've been graduating out their students since the probation period. So 5 students total.
And these 5 students are graduating or have already graduated?
They're in their 4th year, so they'll graduate at the end of this school year, and they contemplate that they'll start enrolling new students for the first time in a number of years in January, and so that's what this motion would approve, for them to begin admitting new students in the unaccredited distance program in January. These remaining students would graduate from an unaccredited school, which would have been disclosed to them over the past 3 years.
Okay, thank you.
Anyone else? Natalie, can you put up the revised motion?
Sure, of course. Give me a moment to share my screen. Okay, can everyone see my screen?
Yes.
Okay, thanks. Okay, so here's just about all the full motion. I'll scroll down for the end, but we'll take it a piece at a time. Here's the paragraph that was added, so that if students transfer from this school, they'll be treated like any other transfers, and they do have the opportunity to transfer at this point to many schools, though some schools require 2 years of residency if they were to do so. But quite a few people did transfer from the school, but these 5 chose to stay. And consistent with the school's commitment, they are there on full scholarship, as was this past year's graduating class. And then here's the bottom part that would have been on the next slide I show you. In addition to the grant of registration that we talked about, there's just a paragraph reminding the school to fully inform its students and the public, and then also to add a progress report in its annual report regarding the transition to ensure that everything goes smoothly.
And can you scroll up to paragraph above the one that's on the top there? So, okay, further move. The law school should be granted permission to teach out its current 4th-year students. That does not make clear that they would be graduating with a degree from a unaccredited school. Because I think normally when we speak to a teach out, we're talking, or it's at least ambiguous about what the status is of their degree. So,
Is that one?
I think that last part could go without saying, but that's fine too. And then, but it shouldn't say the law school should. It should say the law school is granted permission. Should is ambiguous. One line up at the end. That long sentence, the law school should be granted permission. It should say law school is granted. All right, it's all the proofing I've got.
Hey, Natalie, this
Yeah.
is Robbie. Hey, Natalie, I so value the incredible amount of work you put into supporting these law schools. Why is it that you propose that we grant this school's request for registration as an unaccredited distance learning law school? It does not seem like they've earned that.
The staff recommendation is based on this. You have 2 programs. I'm going to stop sharing here for a second. You have 2 programs to offer to schools, the accredited and the unaccredited. The school has not demonstrated that it can meet the accredited requirements, but it does prima facie make the showing that it will meet the unaccredited. And so that's the reason to grant that. But as a result, the unaccredited category more truly reflects what its performance has been. But you notice we also suggest some controls to help make sure that it is successful. The first one being their progress report, with the confirming inspection to be held thereafter in 2024. Because hopefully when they continue to work on these improvements, we'll see improved results, or at least results that conform to this set of rules and guidelines in the unaccredited sphere. So they don't meet the current rules for where they are, but they appear that they will meet the more flexible rules for the unaccredited program.
And just what is it about what they've said or done that makes you think that they can or will? Because if we say yes, they're going to start marketing to who, I don't know, their school for enrollment in the winter quarter. And wow, I mean, they haven't demonstrated that is of any going to be of any value to those prospective students. That's my concern.
Well, we need to remember that there are current registered schools that have lower NPRs than theirs. So they're in the realm of unaccredited schools, they are not particularly at either of the margins.
And so one thing that you might want to think about, Robbie, is that as we think about this, the committee will be thinking about revising the unaccredited rules and thinking about what's contained in those rules. Should there be some benchmarks or markers, for example, the way there are in accredited schools, et cetera? What are the standards that you want the unaccredited schools to evince? And not to put you on the spot here, but I think that could be a really useful discussion to have. So far, for the schools that haven't met the NPR requirements, they have all become unaccredited schools. Pacific Coast University is one. Southern California Institute of Law is another. Lincoln Law San Jose is a third. It's relatively recent that they have transitioned. SCIL is actually being inspected today off-site by the team, and the other two are about to be. So we'll see what those transitions are like. It's relatively new that they are, the NPR is back and that they have moved. So that will definitely be something we'll need to know and that we'll want to share with you.
Yeah,
Thanks, Natalie.
this is Robbie Wannabe. I when I inspected the school a few years ago, I was very optimistic that the school had a lot of resources, had a lot of backing financially or in terms of human resources from the parent corporation. And Dean Weimer is certainly doing everything he could to make everything work. And I think for the last couple of years, I personally have seen, just based on report, he's making good faith effort to comply with the minimum passage rates, and I certainly I give him credit for making all the good faith efforts. I've seen it, and in fact, I would say for the last couple of meetings, I certainly have seen him dialing in, listening to our conversations and all the meetings. I certainly, again, I think from my perspective, Dean Weimer certainly, as the dean, has or is trying to do everything he can to help the school. That being said, I think allowing, and this is obviously coming from me personally, I do think it would be a good thing for the school to continue on as a registered unaccredited school, because that in essence gives them a motivation to bring themselves into further compliance, right? I think we have seen them in compliance with respect to a number of other items, right? This is just the passage rate that is probably the major hurdle, I would think. But honestly, it's not that far up from 40%. And so, giving them this this registration would allow them, hopefully within the next year, to do more to help the students and perhaps bring themselves back into compliance and then come to us again for further accreditation. What I don't want to do is not to leave them with no motivation to continue on. So that, again, that's just my perspective. Welcome any other insights from any member.
Any other comments?
So Jim Efting, I'll make the motion.
Okay, does anyone need to see it again? You saw it just a few minutes ago from the memory.
And this is Robbie. I'll second it. Thank you very much, Mr. Chan and Ms. Leonard, for getting that clear for me. I'll second the motion.
And thank you to Mr. Chan for being part of the inspection team back when that last happened.
Okay, anything further from anyone? Devin?
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora, Dolores Heisinger,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak,
Yeah.
Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Paul Kramer.
Yes.
With 11 yeses and 0 nos, the motion passes.
Okay. Next is, well, how about a 5-minute break? Does people want a break? I see a couple of yeses, but let's make it shorter. So let's come back at 3:05, if that's enough time. Shorter than 30 seconds, oh well.
I have a question.
Okay.
Since we're going into a 5-minute break, is the next item People's College of Law after the break?
No, it's San Joaquin
Okay.
College of Law.
Okay.
the committee.
I'm late, but I was also very stingy with the amount of time I allocated there, so I'll get started when people, Natalie's back. Okay. Next item is under educational standards is C, action on motion for a major change to add a distance JD program at the San Joaquin College of Law.
Yes, and we have the Dean Jan Pearson as well as Dean Justin Atkinson here from that school. So this is an accredited school that's in the Valley in the Fresno area. It's been there for quite some time, operates a fixed facility program. They would like to add an online program in addition while continuing to host the in-person JD. The school is well knit into the community in the area. Many individuals from that school have gone on to be district attorneys, public defenders. The main district attorney or public defender for the county. Many judges have come from the school, including a judge that sat briefly on the CBE here. They're taking that same level of commitment to this program. The online program that they propose is fully compliant. It will mirror the curriculum of the in-person program, which was just approved by the committee in their last inspection. And every opportunity that's available to an in-person student will be available to an online student, including participation in their two very successful clinics, as well as externships. They have some experience doing out-of-area externships, and they would like to gain experience having even more. It was very easy to work with the school. They were very responsive. When staff requests were made at 8:30 one morning, 3 different staff requests requiring 3 different staff actions were complete at 9 a.m. that same day. I would commend this school for really a model application fully approved by WASC before it came before you, and staff recommendation is to grant.
Okay.
I would move.
Well, let's hear from the dean. The deans, was it?
Yeah, so we have Dean Pearson and Dean Atkinson. I'm not sure if they have anything further to add. I don't see their hands, although I know they are here. Oh, here we go. I see Dean Atkinson raising his hand.
I think Dean Pearson, I think you have to hit the button at the bottom that says raise hand. Hi, everybody.
Thank you.
I thank you, Natalie, for that great description. I appreciate the time that you gave to us, and we'd love to be responsive. I don't think I have anything to add other than I think this is going to provide a lot more students, at least initially in our area. We're in a very rural area, and there are a lot of students around who are commuting from Bakersfield, from other places, and we're hoping to kind of ease that burden on them by providing a distance kind of blended education. So that's all I would add. I'm not sure if Dean Pearson is on yet.
I think I am.
Oh, there you are. Okay.
Well, I also would point out that the 5-year cumulative pass rate for the school is 79.7%. It happens that the last 2 graduating classes have actually met the ABA standard for bar passage. The standard says that a class must reach 75% within 2 years, but our most recent class met that standard within a single year. I won't take your time up by sharing a lot of statistics with you, but the different groups of every kind who graduate from the law school also pass the bar at very high percentages. And sometimes the Latino students graduate at higher percentages than the Caucasian students. the men higher than the women higher than the men, but it's not ever very divergent.
Okay, thank you and congratulations. Does anyone have questions for either the deans or staff?
I'll just make a comment. I also did the site review there several years ago, but I will say this, it's a remarkable school. A couple of my associates, I hired them out of this school. And I think, if I may be correct, Dean Pearson, I think at least over 50% of the judges in Fresno County are graduates of your school.
I don't know if it's that high, but there are quite a few. We have 66 judges, commissioners and administrative law judges that are grads.
It's quite high, and but I applaud you on your students. In fact, I got two individuals from your school who I hire as law clerks right now.
Okay, any other questions or comments? Motion, Natalie?
Or I'll ask Devin to bring up the PowerPoint.
Sure.
And I think one thing that's really nice about this program as well is that very often you're putting communication or reporting requirements. And here in the school's motion, they did it themselves. They talked about the analysis they did over the course of the pandemic and the analysis that they plan to do. So that was really helpful to staff.
I'll move that the Committee of Bar Examiners receive and file and grant San Joaquin College of Law's major change request to add a fully distance learning JD program.
This is, sorry, this is Robbie. I'll second.
Okay, any other comments? Devin?
Dr. Bolton? Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora? Dolores Heisinger?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence? Esther Lynn? Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Paul Kramer?
Yes.
With 11 yeses and 0 nos, the motion passes.
Okay, Jim, I've been kind of stepping on your toes. Do you want to run these additional items?
Doing fine. Let me step in. I can.
Step ahead, okay. Next item is action on another motion for major change. Amended motion for change of headquarters for Western Sierra Law School.
Okay, so this is a return motion that the committee requested in June. In June, the school's inspection report was reviewed, and it was accepted, and the school's registration was extended to be inspected again in 2 years. The school also asked for permission to teach in a blended format, which is something that's available to accredited schools, but not to unaccredited schools, which must teach principally in the category that they choose. At that time, the committee had some questions about the space that the school was going to have available because the space designated for the fixed facility school had been used for other purposes during the pandemic. The school filed a timely notice that showed its materials, it showed its space, its classroom space, its classroom library, changed from those other uses during the pandemic. And so staff recommendation is to affirm the grant of approval of that space as appropriate for in-person instruction going forward. And I think that the chair may have a further question about the website, but this is the motion before us regarding the site. And I do see that the school is here and is prepared to make public comment.
Jim, if your question is for the school, why don't you ask it so they can address it in their comments?
I'm sorry, I'm trying to pull up the website now. As I recall, Natalie, the concern was that this was supposed to be only on-site teaching, not remote teaching, and the website suggested that remote teaching would be permitted.
Yes, so what the current website said at the last staff review and your review that you brought up in committee was that students can attend via classroom or via virtual synchronous classroom, which the State Bar would consider distance learning. The rules do allow some mixture of modality so long as it's principally by the stated instruction. That really was created so that distance learning schools could occasionally have a meeting in person or two. But I suppose it allows for some distance classes in a fixed facility school, but it's not appropriate for a school to suggest that a student can attend fully distance or even principally distance when they choose to remain in the fixed facility category. The school's been advised multiple times that it can apply to choose the distance learning category and then offer that increased amount of hours in the way that the rules require, but the school so far has indicated it doesn't want to do so. So it seems that the website needs to be modified. Staff did send a request for a response in writing from the school, so it could be read here, but the school did not provide a response.
So the issue is that the website seems to say that they offer something which they're not permitted to offer. And if they wanted to offer it, that would mean they would have to provide a different type of teaching environment than they're offering now. That's our issue. Yes. Okay. So maybe we can hear from the Dean.
And Devin, if you could recognize Dean Joshua Schoonover, Western Sierra, please.
Hello, you all. Can you hear me?
Yes.
Okay. Dean Josh Schoonover from Western Sierra. There seems to be a lot of confusion and going to need a lot more than 5 minutes. But to just start, I want to say the law school is committed to operating within all of the statutes, rules, and guidelines. We do, however, have a difference of opinion regarding the express construction of the rules and guidelines as they stand. We have filed a petition seeking review from the committee, and we have not received a response. It's been, more than a year and a half. I don't have the date in front of me because I wasn't prepared, as this is not on the agenda. But we do have an outstanding petition. We're waiting to hear construction from the State Bar and the committee regarding how they interpret those rules. We have provided our subjective but plain and ordinary meaning construction of the rules and guidelines, and we believe we are operating within them. So without any sort of guidance, I'm not sure how we resolve this. So perhaps this should be taken on another agenda item. I'll stop here and see if there's any other questions.
So Dean Schoonover, as a point of clarification, it actually was taken up at the June meeting and the school's petition was shared with the committee. The school's interpretation of what a classroom means and whether synchronous is distance or fixed facility was discussed. It's considered by this committee to be distance learning. So there was in fact a decision. We would be happy to send a copy related to that.
With all due respect, Ms. Leonard, if you refer back to that committee meeting, there's nothing in the agenda regarding the petition. There's no copy of the petition or the written submissions that the school has provided to the State Bar. I do not believe it was considered or discussed.
Reply, Natalie?
I don't have the same point of view. Perhaps a solution may be to have the school resubmit so it is clear exactly what it would like to have before the committee. But it is important that the school refer back to the June decision by the committee in which the school was instructed that it did have permission to operate a classroom program in which the students were physically in the classroom principally, and that will be required in order for the students to be qualified for the bar exam. It would be unfortunate if the school disagreed with the committee's June interpretation and put its students at risk of failure to qualify for the bar exam.
Ms. Leonard, thank you. I do agree with you to some extent, which is why we filed a petition, which is also why we filed 2 additional extensions of the COVID waiver to allow the committee to review the petition and to provide some sort of a response. The committee has never responded, and so you have also not allowed continued waivers. So we have no choice but to operate as we feel is within the rules and guidelines, giving a plain and ordinary construction. So at this point, I'm afraid, we have to stick to our guns here, and we have to request the bar to respond, to give us, a written articulation of how they feel the rules and guidelines read, and contrary to what we communicated in our position. And if you don't do so, perhaps give us a notice of noncompliance so that we can then have standing to seek, redress at the Supreme Court.
Okay, I put the minutes of the June meeting on the screen for, to the extent they help. And the relevant paragraph would appear to be this one here.
Right, but if you recall in my public comment in the last session, I said that there should be no request for major change because the major change is not necessary given the construction of the rules and guidelines. That was not addressed. In fact, I believe in the recording, we can look it up, the State Bar refused to comment as to construction of and interpretation of the rules and guidelines. So it seems you have agreed with me and denied the major change because it's not necessary.
I can pull the recording. I probably cannot do so at this moment without a short break to do so. It was verbally discussed and perhaps should be memorialized in a further motion by the committee if you find that to be necessary.
Okay, well, we can't spend a lot of time this afternoon.
Understood.
Solve this, but you
perhaps
go forward.
If I can suggest, Mr. Kramer, if I may suggest to perhaps the committee should ask State Bar staff to regroup with the law school to identify these issues and to return in the October meeting.
Okay, but you want to try to teach remotely in the meantime, correct?
Well, we're teaching principally in fixed facilities with an extension to the synchronous online classroom extension.
But doesn't that extension expire real soon?
I don't think so. I believe we're allowed to do that under the rules and guidelines.
It expires at the end of August, but there is a rule that contemplates that some distance learning could be incorporated into the fixed facility program. It's just that the school is representing that that could be up to 100%. And
well, no,
we don't have clarity from what the school is intending.
Or
yeah, so I
for some
suggest
students, it would be 100%, and for others, it would be maybe just a few percent. Yeah, we don't average across students, I don't think, in applying that standard, unless I misunderstand it. Suggestions, staff, as to Jean?
I have a question for Jean as a point of clarification. The committee discussed in the June meeting as to whether or not this was allowed under the rules and indicated it was not. I see that that's not further, that's not included in the motion. It wasn't deemed necessary for that to be the case. And the plain language of the guidelines talk about synchronous distance learning and in fact require that type of distance learning for school that chooses the distance category. So it would seem that the school is placing its students at risk. What would you propose, what would you recommend as a next step, given that the committee has already had a verbal discussion and presented its point of view?
I mean, the committee could agendize at a future meeting to discuss this if that's what it would like to do. My understanding of what is on the screen now is that the request specifically made by the school was rejected at the meeting in June.
Mhm.
Well, I guess, I mean, one quick way to resolve this might be, or the quickest way might be to bring back a notice of non-compliance in October. And Dean can explain his interpretation. And if the committee continues to hold what we believe is the previous position, then they might find themselves in non-compliance in a compliance proceeding. I'm just wondering if we want to pussyfoot around it and bring back another discussion and then have to, you know, bring a notice of non-compliance in December. Should we just push this thing along through probably the only process that's going to resolve it, or at least tee it up for judicial review?
Well, Paul, we have a motion before us that really doesn't deal with this issue, and I wanted to raise it because it's a concern to me, but it probably doesn't need to be dealt with today with the proposed motion. But if staff believes that the school is out of compliance, then staff can issue their notice of non-compliance, and then it'll come before us. But I don't think it has to be addressed anymore today. I've made my point. I think there's a problem here.
No, okay, I agree. And that's not necessarily related to the topic that's before us today. So, yeah, understood. Anything else from the dean? Regarding the, what is it, the change of location?
The only thing that I might suggest is the school has shown that it has a classroom space that appears to be sufficient for all of the classes that it intends to hold for its student body. I don't know if the committee feels it needs additional information or would like a staff request from the school to provide an audit for each class held until the committee meets again to determine which students were physically in the classroom versus attending via the synchronous learning or any other method of learning.
Yeah, I wonder if that's something that doesn't really relate to the change of headquarters as such. I think that's probably something we have to ask for during the compliance proceeding.
Okay.
It has not yet been initiated, but I guess I'm suggesting perhaps should come soon.
Okay.
Or looked at least, yes.
Yeah. Well, notice of non-compliance is simply saying, hey, we think there's this problem, come in and tell us why we're wrong. And then it goes from there.
So
Okay.
are you ready for me to make the motion, Paul? Jim Matthew would
We
make the
need
motion.
Paul needs to stop sharing.
I believe so. Who did?
So Paul, you got to stop sharing.
You have to stop sharing your
Oh,
screen, Paul.
sorry. Yeah.
So again, Jim Efting would make that motion.
This is Michael. I'll second that motion.
Further discussion? Devin?
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes. Oh.
Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Paul Kramer.
Yes.
With 12 yeses and 0 nos, the motion passes.
Okay, the next item is action on the probation progress report for People's College of Law.
And Larry Kaplan is recusing. I see him.
Yes.
And I believe that Alex is not here at this time. Otherwise, Alex Lawrence would also be recused.
Sounds familiar.
Yeah, he's not.
Thank you.
Mr. Kaplan is left the room.
Okay, thank you. Okay, so this is a progress report from People's College of Law. Since the committee last met, the school filed 2 progress reports, timely July 1st and August 1st. The school was asked to file monthly reports when it was placed on probation in December. So there have been compliance requests from the committee in place since the beginning of 2020, in particular in a probationary context since 2022. But the school continues to struggle with basic concepts. We did hear from 2 students at the school who are 3Ls who are very happy there today. We also heard from another individual who is not happy with their education. And just since the last committee meeting, we received 3 additional complaints, 1 from someone who spoke today and 2 from 2 additional students about students that are having issues at the school. There seems to be a chronic issue with limited documentation as to what will be provided in a course, what credit will be provided, whether the students have completed the courses. With respect to the school's location, you see the location item is withdrawn, but it changed many, many times over the course of the summer. And ultimately, actually, the school will remain in place for the school year, and we'll be bringing to you at a future point its motion for major change of headquarters when it locates a space. It is undergoing some renovations right now, stemming back to problems that began as early as 2017, but also in the summer. And in the spring during the pandemic, and it doesn't plan to finish that work for until the day classes start on September 5th. It's very challenging to follow the progress of the school. The school will offer an initiative, and then in its next progress report, will make no mention of that initiative and offer another one instead, or not explain why timelines change. The school has made progress in a couple of areas. It did issue refunds that were due to students due to errors in the school's disclosure process. It did hire contractors to make the space habitable to be able to be teaching in September. And it did provide a transcript to a student who requested one and experienced a delay on 3 separate occasions when there were delays in the transcript process. It does appear that it is time for the inspection that was contemplated as part of the probation order. And so the staff recommendation here is a grave amount of concern about the school's ability to set standards, monitor those standards, and complete. You have an unredacted version of their performance and their exam scores, which raise questions as to the outcome of the school's education as well. Staff motion is available, and I see that Dean Pomposo is present in the audience. Jim, would you like to speak before we recognize Dean Pomposo?
No, let's listen to the dean, I think.
Thank you. So please recognize Dean Pomposo for 5 minutes, Devin. Thank you.
Good afternoon. This is Dean Pomposo. Can everybody hear me?
Yes.
Yes.
Yes. Hi, good afternoon, members of the committee. I am pleased to inform the committee that we have been making significant improvements in sustaining our compliance and moving towards the direction of remaining in compliance. There have been challenges, but I think that given the circumstances, they have been resolved rather successfully, given our circumstances, if you take the circumstances in totality. First and foremost, a challenge is the resources. So we are in the process, how we're going to solve that is that we are in the process of securing a line of credit. We have applied for the line of credit, and we are working with the lender to submit the documentation and go through the process to secure that funding. With those funds, we intend to build capacity and provide more resources to the students. I feel like in order to run an organization, a business, any entity, you need to be staffed appropriately. We have relied on volunteers in the past, but currently we're taking a more significant approach and to actually invest in the infrastructure, because we believe we want to achieve long-term sustainability. So for that matter, we are awaiting our line of credit, our funds from the line of credit. Number two, staff is correct. We have decided to remain in the current building to continue our search to buy, so that we can locate a property to move the school into. Within those parameters, we have been a significant contribution to the community for the past close to 50 years. And so we would like to remain in that same community. An issue of ample parking for students is also one of the criteria that we're looking for while we search for this building. Given the current market, we don't have a lot of availability in the real estate space from which to choose from. So we decided instead, as a committee, to opt to wait and to not displace the students, and to instead invest resources into cleaning and fixing the building that has not been in operation since that has not been occupied since before COVID. So number three, we also have come into compliance, spending a significant amount of resources in the library. We have invested significant cost in the tune of $5,000 a month to bring all of our library materials in compliance with the unaccredited guidelines. So that should demonstrate that we have we are here for the long haul. We are here we want to meet compliance. So we've just had some issues, but we are working through them. With those additional funds that we are expecting in the interim, we can start to build capacity. We can hire a faculty assistant that can help with the organization of faculty resources, that can help with sustaining compliance with all the faculty deadlines. So and in terms of operations, for instance, by the start of the fall, PCL has moved or has taken advantage of the free resource through Canvas. So all the courses are organized and in Canvas. So the professors, when the first day of school begins, they will have their syllabi readily available, the Cali logins, their email addresses, all the information that they need to successfully teach at PCL. That is something that hadn't been done in the past. And from now working at PCL to almost about 10, 11 months, I can tell, that is something that was much needed, an organizational method in terms of providing the resources to the faculty. So we do continue to move to compliance. I think once we move back into teaching in person, I think it will be much easier. that is what we are used to, and that's what our business model is set up for. So I think going back to our natural habitat is going to be something that is going to be very beneficial to us. And yeah, I hope I have addressed most of the major points, but I thank you very much.
Thank you. Jim or anyone else, any questions or comments?
Well, I think at least my concerns are that this school just isn't going to make it, that they keep moving around and going different directions, but they really are never going to be compliant and they're never going to be able to make it work. But I think as Natalie suggested and the motion suggested, we really need to go down and see what's there on the ground, get some boots on the ground to see it. I think, Natalie, we're talking about an actual physical in-person inspection rather than online, or what were we thinking?
We likely can do it remotely with the schools on site. That's how we're conducting the inspection that's going on in parallel today. So I would suggest that format with people on site there. Couple of quick questions to the dean while we have her here. Construction, is construction still scheduled to complete no later than September 5? So you would be able to be in the building after that time? Oh, I'm sorry, I did it after she's muted.
Okay. Yes, absolutely. That is when the contractors are set to complete even before then. So we're just, working very hard to be able to not have an issue for the first day of class.
Okay, and then one of the other elements suggested for the motion this time is that we received 3 questions regarding transcripts and discovered instances in which courses that students took were not on their transcript. So we encourage that you amplify the need for the school to do a complete audit of each student's study. Remember, they have fewer than 20 students, so this should be manageable, to ensure that all courses that students have taken are recorded. And it's hoped that the school would just generally look at its curriculum plan and advising this could happen.
Natalie, are we going to be able to talk to the students outside the faculty when we do our inspection? I really want to hear what the students have to say.
Yes, we generally have an audience with the faculty alone without the administration, and with the students alone without the administration. We also send an independent email to all of the students. They can respond either in an identified manner or in an anonymous manner.
Okay. Is this going to be over several days?
Yes. And I wanted to note something else that we suggested in the staff memorandum. Typically, a school creates a self-study, and there's nothing preventing the school from doing so here. But rather than requesting that specifically, staff recommends that you use the progress reports, because these are more detailed than a self-study generally would be. And this is the school's opportunity to give as much detail as possible to the committee. So it seems they should be able to be taken as the basis for the inspection, allowing it to happen sooner.
Other questions? I generally agree with James about, or Jim rather, about what the future might hold for the school. I mean, I'm still not confident in a lot of ways, because the reports have come back, although the last couple have been timely. Things change. So the last meeting we had, the weeks prior to that, the school was talking about moving, and they had a site, but they never came up with that site. But at that meeting, all of a sudden, well, here's where we're moving. Now it's a month later, but we're not going to move. We're going to stay here instead. And then we're going to get a line of credit as another means. So I just, taking a deep dive into this, I mean, I think that this committee needs to know these details in a very timely manner. For example, a line of credit, how is that happening? Who's the bank? What is the amount? When are these funds going to be available? Will they be available on time to complete this construction on time? Usually
you know, that's paid right away. It's not paid by credit. And also what happened to the other building. So those were the things that were having that building was supposed to make this committee more confident that this move was going to happen. It was going to happen on time. And it's not putting any students at risk about how they're going to, you know, continue their education. Now, all of a sudden, within a few weeks, there's a change of
I
plan.
think it may be helpful for the committee to know also a staff challenge in working with this school. Its schedule is very clear. Provide full information on the first of the month, but very often each month, this month and last month as well, key elements are omitted or key elements are changed without explanation. And we don't receive updates unless we ask for them, often multiple times, and we generally are receiving information right up to the day of the meeting, either the initial information from them or material pieces of clarification. So this further throws into question the staffing level, the commitment level, the ability to execute a strategy, and places a burden on staff, turning attention from other schools that may have applied timely and put together complete materials for the committee to consider. And that's a surprising choice on the part of the school, given the elements of their probation.
This is Robbie. I just have to follow for one moment on what Vince, unless I have a distinct recollection at our last meeting of the school representative saying that they had sold their building and had purchased another one. So it's sort of it seems like that was really a misrepresentation. It's because it doesn't sound like, or Natalie, am I misremembering what was said at the last meeting? I don't want to accuse the school of.
I believe they said that they had sold the building. It was in escrow, and they were either had just made or were about to make an offer on another building, which does not appear to be accepted as of this date. And Dean Pomposo, if I've not gotten that correct, please raise your hand and we'll have you correct it. Part of what they provided, but again, only after staff request. They did not provide the documentation until requested multiple times. They provided the contract indicating that the sale is in escrow, that there is up to a year for the escrow to close, and the agreement with the school the space downstairs to use that space if the construction doesn't finish. And Dean Pomposo does have her hand up. Dean Pomposo, if there is anything to add or clarify, please do.
Yes, actually, Clemente Franco, who is our PCL president, and he is on the head of the building committee. He's present. I would like him to be allowed to please update the committee on the sale and the purchase. It's delineated in the reports, but I think since he is available, would you please allow him to speak?
I'm sorry, but how is he noted?
It's Clemente C. Franco.
Let's see if I see. He might be under another name in our audience, because I do know his name, but don't see it.
Let me check.
I see your vice chair.
Or Hector Peña, who is our vice president, our vice chair. He may also be in the audience.
He is. Would you like to recognize Hector Peña briefly?
Oh, Clemente says that he is he can't unmute.
We don't see his name in the attendee pool is what we're saying, Dean Pomposo, but does he have a more up-to-date information?
He does. He is on the phone.
Oh, is he the ending in 2500?
Let me check. One moment, please.
In the meantime, are there any other questions from the committee?
I do have one clerical change to the motion
Oh, thank you.
on the further moved. Well, I think it's the next, no, the last further move
Mm-hmm.
has the committee twice.
Okay, let me find that.
What page is that on, Jim?
12 of 228.
I can share my screen with the revised motion. Thank you, Jim.
9221, I believe, is the last 4 digits of Clemente's phone number.
I see
Yeah,
him now.
Oh, you see him? Great, thank you. Oh, I see him by name now.
Thank you.
Okay, you are recognized for a brief comment. Chair Franco.
I'm sorry, can you hear me?
We can.
Yes.
Thank you. Thank you for the time. So just to give you a little update on the building. So what's happening is PCL, People's College, did enter into a contract to sell the building and was in the process of purchasing a building. So it made an offer on a building and that offer has not been accepted. So it never purchased another building. It's still in the process of identifying a replacement property or replacement building. But at this point, it has not purchased another building. So that offer that it made, technically it's pending, but it doesn't seem that it's going to be accepted by the sellers, who happen to be 2 individuals, and apparently one is having second thoughts about it.
And Vince, further to your question, is there anything further that you need regarding your concerns expressed as to the school's ability to secure or responsibly pay back a line of credit, or anything else that you asked about?
Well, I understand that things change in real estate rather quickly, but it seemed, it was characterized to us that a sale was going to happen. And I think that, at least for me, that's how I took it. So, from a mile high level, it just seems like that's what was going to happen. And, when you say you're in escrow, I mean, kind of like you're ready to go and the wheels are in motion, but it doesn't seem like it got that far. So all I'm concerned with is that, whatever moves the school makes, that we're informed. I don't see why you have to wait a month, especially when we're getting close to these deadlines when the school is going to reopen in the fall. So, theoretically, the next report we get would be, soon, right, in the next month. But just in this last 4 weeks, many things happened. And, I don't think we were apprised of everything in the kind of detail that we would need to make decisions on the site. And as was said last time, we're not trying to close the school down. We're trying to help it, to maintain its reputation in the community. So the issues that I see are that the administration, and if I'll just be frank, is not providing timely or accurate information to this committee for us to understand what's going on and for us to support it or not. That's all I got.
Can you put the motion up, Natalie?
Sure, I will put it up because I changed a portion of it in response to Jim's comment. There we go. That's the full motion.
It's not on.
Oh. Here we go.
Okay, Jim Efting will make that motion if anybody's got any questions.
Can you allow me a second to review it real quick?
Okay, I'm gonna go back to the top and then you tell me
Yeah.
when to slide down.
Okay, go ahead.
Hey, Jim, this is Robbie. You're supporting this?
Yes.
Because I feel like we've been misrepresented, but I know you put in so much time into this and I value, I'm gonna follow you, but man.
But the point of this is we're gonna do an inspection to find out what's really going on. And I suspect the next meeting, we're either gonna come back and say that, there are serious issues with the school and we've got to take the next step, or, they just aren't being clear about what they're doing, but they are towing the line. So that's why the inspection here is really what's key to this.
Okay.
And my understanding is I'm gonna participate in that inspection. And it'll take place, I think, in early October.
That's what we're targeting, yes.
So quick question, Natalie, this would be like, would that take us to like a 6-month like probation check-in more or less, or where are we at on the
No.
timeline?
So I'm going to take this down for a second. So the school is on probation in a term through May 2024. The way the motion was written, if the committee does not find that the school is making acceptable progress, the probation can be terminated sooner. So depending on the results of this inspection, it may help you to feel confident that the school should continue on its probationary term and can demonstrate success by then. Or it may help you to determine that the committee should exercise its right to end the probation early and close the school. In this case, because the school is an unaccredited school, it doesn't have the option to slide to another category. It would be closed completely.
Okay, then I'll second the motion for the inspection.
You mean the whole motion?
Yeah, I'll support the motion on the floor.
Any further discussion or questions? Okay, Devin?
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Larry Kaplan, recused, Alex Lawrence, Esther Lynn, Bethany Peak.
Yeah.
Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Paul Kramer.
Yes.
With 11 yeses and 0 nos, the motion passes.
Okay, as Natalie mentioned, the next item was a motion for major change of headquarters for People's College of Law, but that's been withdrawn. So after that comes action on a periodic inspection for American International School of Law.
Yes, and I'm not expecting any attendees from that school, but in an abundance of caution, I'll just ask if there is anyone from that school here today, please raise your hand and identify yourself, but that was not planned and the school is not required to attend. Okay, so American International School of Law is a correspondence school of law located in Irvine, co-located with the owners of the building's law firm, and they also are the landlords as well. This school is a correspondence school. It's not required to have interactive experience, but the consultant's observation at the school was that the curriculum is primarily a list of books coupled with an outside additional purchase requirement for students to take the Fleming's first year law students exam program, the Westlaw free legal research exam, and the Fleming's multiple choice prep program. The consultant had a concern about the school's ability to provide that which one expects from a legal education, and thought that perhaps this presentation could be the reason why the why the attrition is so high, nearly 100%, and in some years having zero students by the fourth year, producing very, very few graduates. Therefore, the recommendation for this school is to issue a warning letter regarding the large number of recommendations cited, and to give the school an opportunity to respond. The team suggested 30 days. Staff recommends 90 days through the resulting annual report. This way you can have a real indication of whether or not the school intends to take action or not. And you can use that information for staff to quickly set an inspection if the school indicates there is progress, or to take the appropriate action if there is not. The school has decided not to enroll any new students pending this committee's action today, so no new classes expected this fall.
How many students does it have now?
I want to say it has just around 20.
Thanks.
And the vast majority are first-year students.
So the idea is we'll issue a warning letter and we'll see what happens. The question is how quickly they have to respond. 30, 60, 90 days.
Right, and the idea behind providing the 90-day warning letter is to give them enough time to fully complete the recommendations and document the completion. And so that's what the motion states, and that's what the committee should expect. You should have a full explanation with documentation, or see that the school is unwilling or unable to provide that assurance of compliance to you.
Well, I guess in light of the fact they're not going to take any students this year, I'm fine with the motion, unless somebody wants to talk about it first.
Can you put it up, Natalie? Or Devin?
Sure, and actually, Devin, would you mind putting up the PowerPoint version?
Sure.
Thank you very much.
And it's a little less than 90 days because it's November 15th, correct?
Yes, it's actually probably 2 to 3 days less, but it's designed to coincide with the annual report return.
And when is our next meeting after November 15th?
December 2nd, or approximately then. It's that Friday that week. So it would be a quick turnaround on staff's part, but we would be prepared to do so.
Okay. Well, Jim Efting would make that motion.
The third paragraph duplicates the second in many respects. I guess that's not critical. Maybe we don't want to start rewriting stuff at this point of the day, but
Are we looking for a second? Because if so, Bethany will second.
yes, thank you. Okay, I won't worry about the duplication. Unless there's some inconsistency, that would be bad.
There shouldn't be, Paul. Part of the reason it's written this way is to just highlight that part of what needs to be provided is the actual course content, and the school needs to demonstrate that there is course content. So I know it seems a little bit redundant, but I think it will provide you with helpful information.
Okay. Any further discussion? Devin?
Dr. Bolton? Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora? Dolores?
Yes.
Thank you. Dolores Heisinger?
Yes.
Larry Kaplan?
Abstain.
Alex Lawrence? Esther Lynn? Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Paul Kramer?
Yes.
With 11 yeses and 0 nos, the motion passes.
Okay, Robbie, you had said you wanted to leave at 4, but you didn't ping me. Do you need to go? Robbie?
I'm sorry,
You muted yourself now.
I'm sorry, our visitors were leaving.
Are you about to leave?
No, I'll stay.
Okay. All right. We did the item H, law school performance report. So all we have is administrative updates from our accredited, unaccredited, and ABA law schools. Natalie, is there anything? It's just a report to be received and filed.
correct.
So do you have anything to highlight in there, or?
I think it stands on its own. One point that I'll highlight for you is that Concord Law School will be changing its location from one space to another. It uses a shared office hive, and the company Regus was closing a certain building, so it moved to similar spaces nearby. But also, it will be changing its name from Concord Law School to Purdue, the name of its parent. And it's helpful to note the attached letter from the dean, as well as the dean's quote in a public article indicating that part of the name change is to further tighten its connection with the state of Indiana, where Purdue is located, and where there is a pending petition to allow that school's graduates to be in a school regulated by California, but with eligibility to take the Indiana bar exam. So it might be a future strategic question: what happens when a California law school is strengthening its ties to another state while being regulated by California?
And isn't the word global also in the proposed new name?
It is, yes. So the full
Yes.
name is located in and that Purdue Global is a name that Purdue has been using for its online product offerings. And the law product offering comes out of California because this is where it can get the approval to do so. And it maintains the Regus office share to have the California contact.
I'm sorry, I can't help myself, but I guess the advice for other schools is to top that, they're going to have to find a way to weave intergalactic into their name. I see a couple smiles. Okay, thank you. Any questions about that?
Paul,
Yes.
since David Torres does have a 4:30 hard stop, should we move to report from director to get through to?
Oh, yeah, why not? At least, why don't we do the one item that relates to him? I believe that's the one, right?
Yes.
Okay, and that would be our recognition of outgoing members. So you're going to start, or am I going to start? I guess it's me from that look, yeah.
Yeah.
So, we've had more than just David Torres and Dolores Heisinger leave or about to leave us this year. There was Judge Herman and Judge Guerra, and am I missing somebody else?
We can show all the certificates.
Yes, Dr.
Okay, let's do that. So anyway, personally, I'll start, and then Robbie, I know you want to chime in, and maybe others do as well. I want to thank Dolores and David. I've known David since I was on the board of trustees back right before 2010, and we were all at an ABA convention in Chicago. Believe it or not, when we left the state to convene to discuss things that bar related. Some of you will be saying, what? But we did. And David rented this, let's just call it big, you can fill in the other word, limousine, to take us all out to dinner. And so we've been acquaintances, and I don't know if we're quite at friends yet, but ever since. And I've really enjoyed his perspective on things, his good humor. And I think Dolores started about the same time I did on the committee. I've always found her to be a useful resource, her perspective to be valuable, and she's attended most of our dinners, in the days when we had those, and enjoyed both having dinner with her and her husband Rocky. So I want to wish you both the best and well in your future endeavors, and thank you for all your service here at the Committee of Bar Examiners. Robbie, you're next.
You know, I'm not going to take up too much time, but the two of the CBE members that I most value, unfortunately, are two of the ones that are leaving, but they're both here. And when I got on this committee, David Torres was such an impressive guy. In addition to being very open to working with the new folk, his institutional knowledge, his comments at the meetings, his ability to gain consensus, always being diplomatic and so thoughtful. He's just been such a great resource and somebody that I've really grown to admire. And one of the worst parts about COVID and these remote meetings is that we haven't had a chance to chat and joke like we did. But gosh, David, what a loss for the Committee of Bar Examiners. You will be missed. Dolores Heisinger and I started on the same day together, and I was often asked by other people, hey, I thought you were supposed to be working with a public member. Dolores was so thoughtful, intelligent, lawyer-like in her approach and view that I think many people assumed she was one of our attorney members when she is not. She also is one of the most joyful and giving and friendly. Back when we did our moral character reviews in person, she and I were often teamed up. She's just such a delightful person. I'm so happy that I was able to call her a friend. And gosh, Dolores, as I've shared with you, you are really going to be missed. So both of you, wow, best of luck on what's coming next. I am really going to miss both of you.
And then let's let David and Dolores have their shot at it.
And there's some hands up to Kareem, Bethany, and Alex.
Kareem, let's do Kareem and Alex Chan then first.
Thank you, Mr. Chair. I couldn't let this moment pass without extending my heartfelt gratitude and appreciation to both David and Dolores. When I came on, I was a young guy. I was a new kid on the block. I replaced someone who was here for quite some time, and David and Dolores both opened their arms and embraced me. And I'm just learning that you guys are no longer going to be on the committee, and so I'm just going to I have to let you know in public that I am so thankful. I think the state bar is a better place because of both of yours leadership, your engagement, your level of intellect. And whether we agreed or disagreed, you were just very classy, and I appreciate both of you so much. I know you're going to enjoy your additional time that you take to all your additional activities, but just know we'll miss you, and we definitely appreciate you so much. So thank you from all the way from the Inland Empire to both of you. Thank you.
Alex?
I don't know if that's okay, but I would like to make a motion to stop David's and Dolores' departure, actually, and keep them on the CBE during their lifetime. I just need a second. Oh, it sounds like everyone.
Too.
Oh,
yes,
yeah,
so moved, Brody, so moved.
I really have only one thing to say. I will cry my eyes out and drink my sorrows away this weekend. I will miss both of you and dearly, and from the bottom of my heart. I will miss you guys.
Well, a multi-day bender is a sign of respect.
So Bethany and Vince's hands are up too, Paul.
Yep. Vince, and then Bethany. So let Bethany go first. Vince says.
Okay. All right. Thanks, Vince. Thanks, Paul. So I'm very sad. I did not realize that it was both of you all's last meeting, and it really kind of hurt my feelings when somebody said that earlier. Dolores, you've been such a pleasure to work with. We mainly work together on our moral character appeals, but you always ask the right questions, the difficult questions. Please, I'll echo Robbie, let Rocky know that he will be missed at dinner going forward. It's just been great getting to know you. And Mr. Torres, David is who recommended that I consider applying for the committee. And it was one of the best recommendations and decisions that I've made being an attorney. David is actually one of the first people I met when I moved to Bakersfield to practice. I didn't know anybody. And he was just so kind and welcoming to me. I was sure that he wanted something. And then it hit me that he is just a generous, caring, thoughtful attorney, which is not something I always get the opportunity to come in contact with. And so, David, as you know, I'm sure your years of service to the bar have been just amazing. You can't get rid of me just by leaving the committee. You're still stuck with me forever. But I'm sad that you will not be here any longer. So thank you both for your service, and I'm glad that I got to have this time with you.
Kareem, I think your hand, do you have more to say, or?
No.
Dr. Cal and then Vince.
Yeah.
Wait,
yeah.
how much time am I allotted, Mr. Chair? Can I go on for at least 3 more hours? Just kidding. It was an old hand.
Okay, 3 minutes only.
This is Michael.
Go ahead.
Dolores, because I learned so much from you, and just echoing what everyone else said, you're going to be greatly missed.
Thank you.
Vince.
Yeah, I just, so I don't want to repeat what other people said. It's just heartfelt that you folks are leaving. Dolores, you kind of took me under your wing, whether you knew it or not, when I first came on a few years ago. And I just learned a whole lot from you, and you're very compassionate in the way that we've dealt with issues. I don't think we've always agreed, but you're always so respectful, and we knew how to move forward. So I really appreciate your guidance and your insight. And I'll also miss Rocky at the couple of dinners we had. So please say hello to him. And part of the COVID problem is I didn't get to know David that well because I just got on, and then within a few months we were online. And it just so happened at the last meeting I got to sit next to David, and we found out that we're brothers from another mother. We have a lot of connections with Delano and the United Farm Workers from way back. So I was grateful to get to know you from that perspective also. So I'll miss both of you a whole lot, and best wishes to you in your future undertakings.
Still your hands up, Kareem. Leah.
Hi, I just wanted to say thank you. I thought you were going to mention Robbie. David, in addition to all his other accomplishments, is always the most dapper dresser. I guess you're a competitor for that title, Robbie. But I just remember thinking that from the first time I met David, and I of course had that wonderful opportunity. I don't know if anybody here knows, but to see David in his hometown Element at the Kern County Fair many years ago. That was a lot of fun. But for both Dolores and David, I want to thank you. And just looking at the dates of your terms, you have been with the bar through its biggest transformational period in its history. You were here before the separation of the sections. You participated in the sometimes painful Appendix I process and review of what the committees do in light of that transition of the state bar to a purely regulatory agency. So with you goes a lot of important history, I think, and institutional knowledge, experience of with the bar of yore and the bar today. And I just want to recognize your contributions to our transformation, and thank you both very much for your service. Thank you.
Those of you who participate in the Appendix I drinking game, have a shot. Just mentioned. Okay, thank you, David. I'll let the ladies first. Dolores, your parting shots, don't hold back.
Yeah, sure. So I'd simply like to say how much I've enjoyed my 7 years on the committee. That's a long time. The learning curve is pretty steep, especially when you're a public member. And I remember 7.5 years ago when I received a phone call from the Senate office asking if I'd be interested in participating and serving on some committee called the Committee of Bar Examiners. I was pretty naive. I didn't know what that was. And they took the pains to explain to me that it didn't mean that I had to go down to my local bar and somehow assess their drinks or what they, had to offer. So they actually did explain that to me. That was not, this is not a joke. They said those things. So all of my years on the committee have really given me a greater appreciation of the work of the California Bar. I never would have known half of these things, not even a tenth of everything that I know now. To staff, I'd like to say thank you very much for your hard work and for your attention to detail. And there is a lot of detail in everything that you do, so I commend you. To my fellow committee members, thank you for your kind words. I will leave considering you friends, and it's always difficult to leave friends, so I will miss all of you, staff and committee members alike, and I wish all the best to all of you. That's all.
All right, it's my turn. This is difficult. Paul, you are my friend. And I want to thank you very much for your leadership. And by the way, the guy that hooked me up with that limousine, he still happens to be a very good friend of mine. So if anybody goes to Chicago, give me a call. I'll set you up with a limo over there. I want to congratulate Dr. Cal and Alex Chan Brody on your new leadership position. I know each of you or all of you collectively will do very well this coming year. And it's also my understanding that Justice Mesuala is also going to become a part of this group. I happen to be a part of the Unity Bar with her. She is an awesome, awesome individual, and I know that she's going to make a difference on this committee. I also understand that Alan Yokelson is returning to the Committee of Bar Examiners. I was on the Committee of Bar Examiners as a liaison when Alan was a member of the committee. He is a tremendous asset. He's just a historical base for this committee. So let me go back a bit. In 2012, I was voted by the attorneys in the Central Valley to serve on the Board of Trustees for the State Bar of California. So a year later into my 3-year term as a trustee, the president of the trustees at the time appointed me to serve as a liaison to the CBE. Now, I know we haven't seen a liaison to the CBE often, but actually I enjoyed attending these CBE meetings, and I attended every one. And while we were there, we engaged in a lot of discussions. And as a member of the trustees, I happened to be chair of the Admissions and Education Committee. So because of that, we had begun conducting discussions with Dr. Bolus and other psychometricians, and we started having hearings to determine whether or not a 2-day bar would become viable. And back then, the number one issue was, wow, we'd save $1 million. And so luckily, we had these great hearings, a series of hearings, and ultimately the group, the California Bar Examiners, we voted unanimously to reduce the bar from 3 days to 2 days. That vote then went up to the Board of Trustees. The Board of Trustees then voted unanimously to agree to the CBE's recommendation. And of course, later on, that was ratified by the Supreme Court, which showed how important the CBE was at that time and continues to be. So when I completed my 2-year term as a liaison to the CBE and my 3-year term with the trustees, I immediately made an application to serve with the CBE. And to be honest with you, I never looked back. There's been highs and there's been lows. And for the most part, 95% has been high and maybe 5% has been low. But what has been negative has been forgettable. But what has been positive is going to be memorable. It has been, the CBE has given me the privilege of working with the brightest, most creative, caring, and finest individuals who serve on any bar committee. As to the CBE staff, Audrey et al., I have yet to meet your equal. Thank you, all of you, for the honor and privilege of allowing me to serve alongside you. And most importantly, thank you for letting me be your friend.
Devin, do you want to take the certificates down?
What's that?
I just want to look at all your faces without the certificates up for a second. It's so touching to hear what everyone's saying, and I just, I haven't been as involved as long, but Kareem said the word, I think, engaged, and I think when I think of Dolores and David, that is what we're all looking for as staff, are folks who are really engaged, and I just want to thank you for dedicating so much time to the Committee of Bar Examiners. It's incredibly important to us and to the public, so thank you very much.
Okay, back to business, I guess. You're welcome.
All right.
Let me find my
I have to
place.
get going, folks. Thank you very much.
All right.
Hi, David, we'll miss you.
I love you, Dave.
Okay, we were on moral character, action on revised rule 4.41 of the admission rules. Recommendation to adopt following the return from public comment. Barry or I guess Tara probably take the lead here.
Thank you. So this one will be quick. If you recall, this rule change came before you in March, and then it went to the board in May. It went out for a 60-day public comment where we only received one comment that was in agreement with the change. So this is the current version of the rule. So as a reminder, it does let an attorney who is not in good standing in their home jurisdiction apply here with the rebuttable presumption that they are not a good moral character. And then also, let's see, is it going to change? As you may recall, we have the general rule revisions for moral character. They're currently under review by the court. So you'll see that we have both versions attached in the agenda item. And unless there are any questions, we have the motion.
So depending on what the court does, we'll use the appropriate version of the revisions.
Correct.
Okay. Any questions or comments on?
I'll move the motion. This is Vince.
I'll second.
Okay. One more time, questions or
That's all
comments? Let's take the roll.
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres, Paul Kramer,
Yes.
with 11 yeses and 0 nos, the motion passes.
Okay. Action on guidelines for extending the reapplication period for applicants receiving adverse moral character determinations, our abeyance policy, and the procedures governing informal conferences. Some are being repealed and some are being modified. Tara, if you can straighten that out, explain that.
So thank you, Paul. So as part of the overall rules application revisions for the Office of Admissions, we're also going back through the old policies, guidelines, procedures of the Committee of Bar Examiners and seeing if there's anything that now is either outdated or needs to be repealed. So we have 3 items before you. The 2 first ones, the guidelines for extending the reapplication period and the abeyance policy, those are both recommended to be repealed. The reason being is that they essentially are outdated or moot by this point. So for the guidelines, it was last modified by the committee in 2009. As you may recall, we had the Moral Character Working Group from 2019 to 2020. They formed the Moral Character Determination Guidelines, which includes factors that staff and the committee are to consider in mitigation, rehabilitation, and aggravation when making a determination. And the admissions rules also allow the committee or the state bar to set a denial period at something other than 2 years if it deems appropriate. So we are recommending that that guideline be repealed. It is now obsolete. For the abeyance policy, that one was last modified by the committee in 2012. If you take a look at it, most of the information is duplicative of the rule and the stipulation that we provide to applicants when we do provide an offer of abeyance. Some of it is also unnecessary with the changes to Business Imperfections Code 6060. after some of the changes that were made effective January 2020, and some of the things are just outdated. And then for the procedures governing informal conferences, so we did bring this in December. However, we have further revisions to this. One, because of the reorganization of the Office of Admissions, so just a couple of tweaks there. We also realized recently that the procedures did not specify what would happen for an applicant that did not timely respond to an invitation. So we've added that in, and then additional just clarifications and corrections. So I don't know if there are any questions, but here's the motion.
I did have a couple
Mhm.
about the rule, which I have to find. So to be clear, you're repealing the first two policies you spoke about, right?
Correct.
Okay, so the procedures governing in the informal conferences, that uses the term agrees in writing in a couple of places, but could that be done via the portal or email?
It is done via email.
Okay, so, and we have a definition that is said to make those two things equivalent. Let me share my screen for just a minute. I'm sorry I have to do this, but let me make it bigger. Oh, is that big enough for everyone? See if I can. Oh, here we go. So this new sentence here seems to be unnecessary. Everything, or maybe even conflicting with the yellow highlighted portion above it. Above it says if they fail to respond, the conference is removed from the schedule, and I guess and that sounds like a postponement. I just don't know what the second sentence is adding.
Yes, so in practice, if someone, so for example, we typically send the invite about 2 to 3 weeks prior to the conference. We give them 7 days to respond. If the applicant doesn't timely respond, we were then re-inviting them again at a later date. So this is where we were deeming it essentially as a request for a postponement. And if you go down to K, it says that they can request no more than 2 postponements. So you're essentially we've been operating by those procedures.
Okay, it's a request by inaction in effect, but that you still consider to be a request. Okay, well, I don't see what it adds. And then here when we say an applicant may request to confer off the record with their counsel, they don't have an absolute right to do that. Is that what you're saying? They have to ask our permission?
So they, as a matter of practice, we grant applicants requests to confer off the record. It's conceivable that, an applicant who asks to confer off the record numerous times and does so for a long time, each time they make the request and we grant it, I guess we think we should be able to eventually draw a line because the conferences are scheduled for 45 minutes each, and it wouldn't be fair to the other applicants who are scheduled on the same day.
Okay, I mean, I don't know if it's worth clarifying it, but I don't think it clearly says that. It's just kind of vague. Maybe we like vagueness, but it doesn't state clearly warn them that certain behaviors, would result in postponement of the resolution of their matter. But this has already been out for comments, so I guess I'm a little late maybe I'm not going to consider that my concern to be worth recirculating it for sure. Just maybe a drafting sort of pointer or thought for future efforts. And that's all I had. Anyone else? I'll stop sharing. Okay.
This is Bethany. I'll make the motion.
This is Michael. I'll second it.
Okay, any further discussion or comment? Hearing none, Devin?
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Sorry, I'm muted. Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres, Paul Kramer,
Yes.
with 11 yeses and 0 nos, the motion passes.
Okay, that's all for moral character. Report from the director? The
Yes.
work plan.
You know what, we're gonna skip, Donna is going to go first actually with an update on the fees, the fee increase proposal.
Okay.
Thanks for letting me go out of order. So when last we spoke at the end of June,